Okay, tēnā koutou katoa, nā mai, haere mai. Welcome everyone to this hearing on an application by Farm North Solar Farm Limited to establish a solar farm at 380 Waipara Road, Brook Flat Road, State Highway 7. We'll introduce ourselves firstly. Ko Deegan Crystal toko eno. I've been appointed as chair of this hearing panel. My background is planner. I've been a commissioner for over 20 years and sat on over 100 hearings throughout that time, including a number in the Hurinui district and locally in Waipara. And that included the initial decision on the Mount Cass wind farm. We've also recently completed being part of a panel on a fast track application. And I'll hand over to Commissioner Bray to introduce himself as well.
Morena, ko Shanabray aho. I am a landscape architect based in Hawke's Bay. I have spent the last 20 or 30 years pretty much working on infrastructure utility projects through assessment, energy in particular, a number of solar farms completed, lots of wind farms. I've worked for applicants, I've worked for submitters, I have worked for council, I have given advice to decision makers, and I have sat in on the decision making panel. So I'm rounded on all sides of making decisions and understanding how that process works. And yeah, look forward to working through this over the next few days.
Thanks, Shane. So just to introduce the council staff, so from Hurinui District, we have Ms. Kirby in the middle here, who wrote the Section 42A report. We also have here today Ms. Silcock, the legal counsel for the council, Ms. Annan, landscape architect, and Mr. Trevathan at far end there. And I understand that Mr. Van der Velden is online.
He'll be watching.
Be watching online, yeah. We also have Ms. Aiken over here. She's helping us look after all the administration matters. I just want to emphasise at this point that the officer's report is a recommendation only. Now, given the number of people here, we're just going to ask you, those present, to introduce themselves as the hearing progresses rather than go around the room. Otherwise, we'll be here all day. A hearing process such as this is a quasi-judicial one, and while we intend to be as informal as possible, that requires a degree of acceptance and understanding from all parties involved. So please respect the rights of others to be heard and don't interrupt in any way. The applicant ultimately at the end will have a right to reply at the end of the hearing, and they are able to respond to matters that are being raised during the hearing. Now, that can be done either verbally or in writing. I understand that they're looking to do that in writing. There's no cross-examination in these processes. We will be asking questions about conditions as we go along. Now, that's not to say that we've made our minds up in any way. It's just that we need to address conditions through the hearings process so that we understand them, should we reach a conclusion that a consent may be granted. If there's any questions, they have to be asked through me, and then we'll decide whether they should be put to the relevant person. I just want to remind experts that they have agreed to comply with the Environment Code of Conduct, and we'll expect all experts to adhere to that, particularly in terms of answering questions and staying within their areas of expertise. In terms of site visit, and we've already undertaken one site visit where we travelled around the roads adjacent to the site and we've been across the site. We intend to undertake another one, which at this stage we scheduled for the 18th of May, which is next Monday, but we may look at Thursday afternoon if that becomes available to us. If submitters want us to visit particular locations, they could indicate those to Ms. Aitken at some stage during the hearings process. When we do a site visit, we tend to we'll be doing those by ourselves, and we are unable to discuss the proposal with anyone during those site visits. Just a few housekeeping matters. So in terms of scheduled breaks, we'll look to break for 15 minutes around about 10:30, about 45 minutes around 12:30, and then for 15 minutes around 3:15. And we'll endeavour to try and finish around 5 o'clock each day, but it may go longer. Now, just the other housekeeping things in terms of toilets through that door over there, and the fire exits. I think you can see one there and one over here. Just make sure everyone switches off their cell phones. You're good. I got caught the other day in the hearing myself. In terms of today, we want to first deal with the procedural matter that arose regarding the removal of the native vegetations. We are initially going to hear from the applicant on that matter, which we identified through minute 8 regarding that removal. And as per our minute 9, the applicant has removed an area from the application in terms of the placement of the solar farm. So we'll then hear from council in terms of their position on the matter, followed by any submitters who specifically submitted on that matter. If we need to adjourn at that point to discuss the matter further, we'll do so, but we don't think that's likely. Following that, and assuming the hearing is continuing, we will then hear the applicant's substantive case. We have a lot of questions for the applicant, and we may end up pushing past 5 p.m. today, so it's just a warning, and potentially into tomorrow. So that's all the sort of introduction stuff. Now, before we go into this procedural matter, there's one thing that I need to raise. So in the supporting documents provided by Ms. Kelsey yesterday, one of those documents included 2 emails from Aidan Crystal to Ms. Kelsey. Aidan is my son, and he worked at Hiranui District Council as a planner up until September last year. I've looked at the emails, as is Mr. Bray and as is Ms. Silcock. They are in the form of responding to questions from Ms. Kelsey, and I do not consider they raise any potential perceived conflict of interest. Also note that I was unaware of the emails up until yesterday. So unless anyone's got any concerns with that, I intend to ask the applicant to proceed. Does anyone else have any concerns with that? Okay, so over to the applicant. You've probably introduced your team, and then I wanted to talk about this procedural matter first, and then we'll get on to the substantive.
Is it appropriate and convenient for the recording that we remain here if you want the experts to go before the microphone?
Please go before the
Microphone, yeah, it's good, yep. Sorry, yes, this has been live streamed as well. Sorry, I forgot to mention that.
Is that okay for the recording? Thank you, commissioners. In terms of, would you like me to introduce the team first before we discuss the procedural matter? Tēnā kouroa, Teresa Labar, counsel for the applicant. I'm a partner at Tompkins Wake, and I do have many years of experience, almost as long as the Act, working for both private sector applicants, public sector applicants, and local authorities. I do have to my left Mr. Richard Homewood, one of the directors of Far North Solar Farm, followed by John Andrews, General Manager, Mr. Simon Coker, Landscape Expert Witness for Far North, and finally Ms. Leila Al-Kamil, the Planning Expert Witness for Far North. We do have observing virtually the balance of the Far North Solar Farm Expert Witness team, which includes Matthew Bubb. I understand the commissioners have asked for him to be available to take some questions. Mr. Ian Hanmore, Dr. Gary Bramley, Peter Ibbotson, Nick Logan. Now, Nick's based in Australia, but I understand he pretty much will be on the link now.
So there's no time issue with him?
Not that I'm aware of, but I have, and we'll address this later, I usually put Nick towards the back of the team to work in with his time zone. But that will be with your leave, obviously. Thank you. So turning to the procedural matter, with your leave, I don't propose to read my legal submissions. They were filed a few days ago. And I understand the commissioners have been reading everything as it has been filed. I did, not while I was driving from Rotorua to Auckland yesterday, but once I arrived in Auckland, I had a quick skim through the Waipara Valley Community Collective preliminary legal submissions on the preliminary procedural point. I just have a couple of observations because I've only had time to have a quick look. My first observation is that neither I nor the New Zealand Law Society Registry have been able to confirm the status of Miss Kelsey as a legal practitioner. There may be a perfectly logical explanation. Perhaps she holds a practicing certificate under a different name. The Law Society is looking into it. The only relevance that has, obviously, for me as a lawyer is how I engage with her, and for yourselves as commissioners is how you interact with Ms. Kelsey. For the moment, it would be procedurally correct to take that documentation as submissions because, of course, laypersons can appear and address the commissioners on any matter. They don't have to be an expert witness or a lawyer, but I thought I should just clarify that from the outset. The second preliminary observation I wanted to make, perhaps like the commissioners, but more recently coming into this application process, it's apparent that there were a number of opportunities available to a number of parties to address the clearance of Indigenous vegetation on the site. But here we are, nevertheless. Mr. Kidner, the landowner, has agreed and has filed evidence to set the facts before the commissioners. He undertook the clearance. He did so of his own volition. He did so in the absence of the applicant's knowledge or direction. And he has acknowledged that he does have a district plan compliance matter to square up to now, and he will do so. The effects resulting from that vegetation clearance will therefore be considered and addressed by this council in Mr. Kidner's own resource consent application process. For these reasons, the applicant acknowledging with the assistance of legal counsel that Section 90 was in fact looming very large on the horizon, made a decision to remove that particular area of land from the application. That does not, in my submission, constitute either an abuse process or does not impose any prejudice on this council or any submitter. The removal of the area of clearance is a reduction in the application site area, a reduction in effects, albeit a small one, because the expert witnesses, through their supplementary evidence, have confirmed it actually doesn't change their assessment of effects or recommended mitigation, and a reduction in the application scope. It certainly does not result in an expansion of any of those things, which clearly would be problematic from a jurisdictional perspective. that is entirely in keeping with long-standing and long-established principles and expectations that have been espoused by the Planning Tribunal and then the Environment Court. And that is that applicants heed valid concerns raised by submitters and reporting officers, and they are expected to refine and reduce their applications voluntarily before decision makers actually impose that upon them. There is plenty of case law dating back to 1993 was about the first Darrick and Whangarei District Council and Old Planning Tribunal decision case. More recently, High Court decisions, Collins and Northland Regional Council, where the court looked at some of the old planning tribunal decisions and quoted, in practice, the lodging of submissions and the presentation of opponents' cases frequently leads to applicants or consent authorities, you, the decision makers, modifying proposals to meet objections that are found to be sound. That must surely be part of the statutory intent in providing for making submissions. And the High Court went on to say that is a part of the resource consent, application consent process, that sensible modifications will be made. It is our submission that the area of land cleared by Mr. Kidner does not now form part of the application, and that is a proper acknowledgement for the applicant to make. No amount of hearsay or insinuation can change this fundamental fact of jurisdiction. If and as required, we will present more detailed submissions in reply if required. But that at this point is all I propose to say on the matter.
Okay, thank you. Just see if we've got any questions around that. I'll just bear with me a second. Have you had a full chance to have a look at the submissions lodged by Ms. Kelsey? You haven't looked at through them?
I haven't. I've only skimmed through them very briefly in and around travel and meeting requirements yesterday.
Okay. And that you've noted a couple of things in there that you've picked up. I guess what I was perhaps more interested in is some of the reference to some of the case law that is in there.
Yep.
And your responses to that.
My initial impressions are I don't agree with them at all. I think they are a conflation and confusion of the case law principles in an attempt to disrupt this hearing. But I can certainly, over the course of the next day or so, respond in more detail. But I simply haven't had the time with the filing yesterday and driving and flying to get here, had time to respond in detail this morning.
Yeah, look, we understand time's been tight on a lot of this, so I think if you've got any responses to that, I guess the other issue you could put those in your
reply. Most definitely. I guess if it helps, I do think there was a curious misunderstanding or contortion of the legal principle of prejudice. What came through clearly to me in my quick skim was Ms. Kelsey trying to advocate that the submitter has spent a lot of time preparing a case based on a non-complying activity status for the vegetation clearance, and now finds itself somewhat aggrieved that all that time and effort is to no avail. That is a layperson's approach to prejudice, but is not the legal principle of prejudice, which is more grounded in fair hearing, natural justice, and proper process. And as the case law makes clear, an applicant that does not respond to valid concerns is at peril itself, as if it does not actually sit down and refine its application accordingly. Refine being reduce. Obviously, one cannot expand the scope of an application at all.
So you wouldn't see the reference to this being abuse of power under the AIM?
Absolutely not. The applicant is acting entirely in accordance with nearly 30 years of case law espoused by both the Planning Tribunal and then its successor, the Environment Court. It's doing exactly what the court would require it to do, which is square up to a valid concern and to adapt its application accordingly.
Okay, can we ask, you said the landowner, Mr. Kinder, has agreed that he has undertook the clearance and he acknowledges that he's got a district plan compliance issue.
Yes.
Can you take us any further in that at the moment in terms of what he's doing about it?
I'm not privy to that information, but I can obtain an update and convey that back to the commissioners, if that would assist.
I think it'd be useful to understand where that's at.
Certainly.
Question, Chair?
No, I don't.
Keep going down here. Make bother someone. Okay, thank you for that.
You're welcome.
I think Ms. Silcock, we hear from you next.
Ora koutou, ko Gina Silcock Pukunga no Otatahi Aho. Good morning, everybody. My name is Gina Silcock. I am a partner at Barowhine and I am the advisor to the Hiranui District Council. I've been acting for the Hiranui District Council for my entire career and have been involved in a number of hearings in resource consent and enforcement matters during my time as the council's legal advisor. The council's asked me to appear today in order to assist the panel with the procedural issue that's been raised regarding the unauthorised Matsugari clearance and also the subsequent modification proposed by the applicant to the solar farm application. And the modification of the proposal has been addressed by the applicant's legal counsel. Further to your questions, Commissioner Crystal, I have had an opportunity to read Ms. Kelsey's submissions and I have endeavoured to read the case law that has been referred to, so I will do my best to assist you with that and happy to answer any questions.
Okay.
As the applicant's legal counsel has advised, it is recognised by the Environment Court that attempts to modify resource consent applications are made at various stages after the lodgement of an application, Reasons for modifications include changes in circumstance following experts' advice as to how to deal with potential effects and reacting to matters that are raised in submissions or reports to the local authority. My read of the case law is very similar to the applicant's legal counsel. There was a quote that Ms. Labas referred to, which is a decision of Judge Shepherd in Haslam and the Selwyn District Council, and that was the 1993 decision that was referred to. And that decision in my submission is one of the first decisions that recognised that the practice of lodging submissions and the presentation of opponents' cases frequently leads applicants or consent authorities to modify proposals to meet the objectives, and that there is, while there's no formal process in the Resource Management Act for that, it is well recognised that that is a valid step to be taken in the context of resource consent processes. The other decision that Ms. Labas referred to was Derrick and the Whangarei District Council. And again, that was a decision of Judge Shepherd, and he recognised that in appropriate cases where consistent with fairness, amendments to design and other details of an application may be made up to the close of a hearing. However, they are only permissible if they are within the scope defined by the original application. If they go beyond that scope by increasing the scale or intensity of the activity or the proposed building, or by significantly altering the character or effects of the proposal, then they cannot be permitted to the original application, and a fresh application would be required. Now, my submission, in the event that the applicant was seeking to authorise the unauthorised vegetation clearance, in my mind, that change would be outside the scope of the application, and they wouldn't be in a position to expand the application to authorise that clearance. Commissioner Crystal, as you recognised in minute 10, it was specifically noted in the application that there would be no vegetation clearance. So in my submission, that wouldn't be a permissible change to the application. However, in my submission, it is possible to reduce the extent of an application as in the way that has been proposed by the applicant. In terms of further case law, the legal submissions for the applicant refer to HIL Limited and Queenstown Lakes District Council, and that was one of the more recent cases where there is, in my submission, very good discussion around the case law on modifications through proposals, and I can make a copy of that case available to commissioners if they don't already have it. What the court in that case held was that a change to a notified application is within the scope of the court, which was the issue in that case, if its ambit is fairly and reasonably within the scope of the original application. And that's a reference to the decision in Shell New Zealand Limited and Porirua City Council, which again is authority for the proposition that the scope of an application can be reduced. And the factors that can be considered include the scale and intensity and character of the altered activity, the altered scale, intensity and character of the effects or impacts of the proposal, and potential prejudice to both parties and the public.
So what was that Queenstown case? What was it?
So it's HIL Limited and Queenstown Lakes District Council, and it is referred to in the applicant's legal submissions. I can give you the paragraph reference if you give me one moment.
Yep, I've got it.
You've got it.
Okay.
HIL Island.
Yeah.
I'm just trying to recall. I think that's a decision of Judge Borthwick. It's either Judge Jackson or Judge Borthwick. It's a useful discussion of the case law on this issue. I recognise the submissions that have been filed by Ms. Kelsey, and there's one who also refers to the HIL Limited decision and focuses on the use of the term normally when it talks about when the scale of an application is permitted, and that's at paragraph 25 of that decision. I think it's really important that you read the full paragraph of paragraph 25. That paragraph states that normally, if a modification reduces the scale of a proposal and in particular diminishes the character, scale or intensity of its adverse effects, there is no challenge to the consent authority or the court's jurisdiction to hear the modified application. That paragraph goes on to say, difficulties tend to arise only when a modification is perceived to increase the potential adverse effects on at least one or more persons. In these cases, the courts have developed a test as to whether the modification is within the jurisdiction for the consent authority or the court to consider. So in my mind, a lot of the case law around the permissibility of modifications to an application are to address those latter circumstances where there may be a perception or an actual increase in adverse effects of the change. As I said earlier, in my submission, it wouldn't be permissible for the applicant to seek a retrospective consent for the vegetation clearance, and Shell Oil, again, is authority for that proposition. In my submission, consent would have need to have been sought for Indigenous vegetation clearance, or at least addressed in the application that Indigenous vegetation clearance was to occur before that clearance could be within the scope of the application. Here, what the applicant is seeking to do is to reduce the scope of the consent application and exclude an area from the application. My understanding is the withdrawal results in approximately 6.8 hectares being removed from the application area. And again, my understanding is the area that is sought to be excluded from the application is where the unauthorised clearance of Indigenous vegetation has occurred. I acknowledge that the change to the application, particularly at this late stage, raises concerns for submitters who have spent time addressing this issue, and I acknowledge that that is a real concern that they have. There are, as has been acknowledged, concerns raised about abuse of process, and there's reference to that in Ms. Kelsey's submission. The case law that's relied on in that submission, again, in my submission, is very different from the situation that is before the commissioners here. The case that was referred to, sorry, I just have to recall the name of it. Sorry, so it's referred to at paragraph 13 of Ms. Kelsey's submission, and the case is Marie Irrigation Company Limited and Canterbury Regional Council, and that was a decision of Judge Jackson. And what was being considered in that case was whether the parties who had lodged an appeal to a consent application had been through a substantive Environment Court mediation process and had filed consent orders with the Environment Court, which were subject to questions and requests for further information, whether the decision, or the actually wasn't a decision, whether sorry, I'll take a step back. The applicant in that case, the appellant, had decided to withdraw its appeal after the consent orders had been filed, and so the issue that the court was considering in that case is whether it was an abusive process to be able to withdraw an appeal after consent orders had been filed with the court. And as I said, there was a substantial process around that, including mediation and various requests for further information and a better understanding of the issues raised by the appeal and the consent orders by the Environment Court. So in my submission, that case is quite a different one to the issue that's currently before the commissioners. But I do acknowledge that it does address in quite some detail concerns around abuse of process in the context of the Resource Management Act. If the commissioners are satisfied that the applicant can modify the proposal as sought, then the activities within the excluded area will not be the subject of consideration. In my submission, the commissioners will want to satisfy themselves that no activity is intended or will be permitted to occur in the area that's excluded by the application. And that will include things like the siting of any solar panels, access areas, construction areas, etc. and conditions to that effect would, in my submission, be appropriate. And commissioners will also want to test the evidence to ensure that the factual basis for and the substantive assessment of effects remains valid, notwithstanding the change in the extent of the application. And on that, there may be some questions raised about the river terrace restoration planting and the location of that. My understanding is it's not clear whether that's proposed to be included in the excluded area, and if so, whether or not that's appropriate. That might be a matter to explore during hearing. And finally, if the area of Indigenous vegetation clearance is outside the scope of the application, then in my submission, the unauthorised clearance is a matter for the landowner and the council to address, and the applicant's legal counsel has provided some further information from the landowner, Mr. Kinder. My understanding and the council section 42A officer, Ms. Kirby, might be able to assist, is that no consent applications have been filed at this time. Very happy to take any questions.
Just going back to that point about the area excluded, that would include, what you're saying is that include any activity related to the solar farm, just make that clear.
Yes, I think.
So, for example, I don't know, irrigation pipe work and stuff like that that might be needed or something that would be excluded.
In my submission, yes.
Driving through it.
Yes.
Yes.
Yeah. I guess just taking that to its end for me, what you're really suggesting to us that our role needs to be to confirm that the effects are reduced by taking that out of the proposal.
I think
the applicant's position.
Yes, I think that's correct. So if there is a reduction in the effects in the scope of the application, then it's a permissible amendment. And then the commissioners will want to be satisfied that it understands the evidence as to effects, and that includes both adverse effects and positive effects.
Yeah.
In terms of the substantive assessment of the application.
Yeah, thank you. That's it.
Have you got written submissions?
No, I don't, but
Sorry, we're just turning up the speaker because people can't hear.
not often people say they can't hear me.
Might be me. Yeah.
Yeah.
Can you hear that now? Can people hear that? Yeah. Oh, okay. I think that the thing that would be useful, I think, is the references to the case law that you're probably just need the references and a link to save paper.
Yeah.
We can make
that would be, I think that's what would be helpful to us, is just so that we can it's really hard sort of writing stuff down and sort of think back to that case law, because I think that's the crux of some of this is around that case law that we need to look at.
I can make those available this afternoon.
Thank you. Anything else?
No.
Okay, thank you.
Thank you.
Ms. Kelsey. Are you getting hit?
No, I'm right.
I might just turn sideways.
We can travel along.
Oh, I've just got this. Being hit by the sun.
Dodging the sun.
I'm
Tricky this morning.
going to be praying for rain for the next 3 days. Sorry, if I turn sideways to you, I'm just a bit more. By that, I'm going to start wearing sunglasses. Okay.
Yes, good morning. My name is Elizabeth Kelsey and I'm representing Waipara Valley Community Collective. I'll start just by addressing very briefly Ms. Slava's point about whether I'm a practicing barrister or not. The answer very straightforwardly I can give you is no. I did explain to Ms. Kirby when I indicated to her that we would be making legal submissions this morning that the collective is not represented by legal counsel. To give you the context, however, I did practice at the public law bar in England and Wales for over 10 years. I have a first-class degree in law from the University of Oxford and a Bachelor of Civil Law from the same university. So hopefully that clarifies that for you, sirs.
Thank you.
The second thing I'll say just at the outset is regarding Mrs. Labasse's comments as to prejudice. And all I will say here is that I entirely agree with her. This is absolutely not a point about prejudice to a submitter in how they have prepared for a case. It is absolutely, as she indicated, about the proper process. Now, you should have my written submission, Sarah, and I think you indicated you also have the short bundle.
Yes. Yep.
Now, I started there with the very straightforward point, and I don't think from what's been said this morning that there's actually any dispute about it, that if you conclude the activity is within the scope of the application, there is no need for a consent application to be gone and made and then to bundle in some way, just as there have been different rule breaches or rules identified in the plan that this application engages. There's been no requirement that a separate consent application be made, for example, to deal with earthworks in the vicinity of a wetland. The same applies here. The crux of the problem has been that the applicant failed to identify in its initial application a rule that would be engaged. It's deeply unfortunate that that's happened here, but it's not legally complex. Section 88 of the Act recognises that applications can be made that are incomplete. It gives the consenting authority the power, if it chooses to do so, to return it, but that's not an obligation. And we've seen here time and again in this application, the council has chosen not to return the application as incomplete, but has continued with it, which is entirely within its power to do. And section 104, subsection 5 of the Act completes the circle and leaves it for you, the decision makers, sir, to decide the activity status regardless of what's put on the form. That's a brief summary of what's in the first part of my written submissions. I don't actually think there's any dispute around that, but there we are. Of course, the big question is what effect, if any, does the application to amend have? It has been set out in my written submissions. I'm not going to take you all the way through those, sir, but just to set out a few things that may not have become apparent. The first is the timing of the clearance and when it took place. And I'm highlighting this because it's a fact that you may not have been aware of prior to our written legal submissions, as it was not explained in either the Section 42A report or in the applicant's evidence or submissions. What happened was the applicant had to make consent applications to ECAN as well as the District Council in respect of the activity to construct and operate the solar farm. ECAN's initial response to that was to say this application is incomplete under Section 88. You have to do an ecological assessment of the site. That decision was made 1 week before the clearance took place. Now, as I say no more other than that fact alone should put you on your guard when it comes to considering this matter. The second point, sirs, and I'll ask you if you could to turn it up. It's in our short bundle of documents, beginning on page 8. These are a series of emails. If you're working it electronically, incidentally, I should say the page numbers will unfortunately be 2 out because there's a contents page, so add 2 if you're working to electronic page numbers. And I'm taking you to these emails to make the point that the council and the applicant has known and the council has been aware that this matter will be dealt with through the consenting process. So it's an email chain, as I said, beginning on electronic page 10. So like all chains, you need to start at the bottom to read it. So if you go down a bit further to page 16, And you see it begins with a request from me to ask whether the clearance that had taken place had been consented already. The first response there, immediately above that on page 15, is from the compliance officer, not to me, but if you look at the headers, it's to the planning team. So the council's response from the get-go on this issue has been not to deal with it as compliance, but to send it to the planning team, of course, because the consent application for the solar plant was in. You see that again then from this response, so from your son, identifying that there was no consent and asking whether I intended to be, I would wish to be an interested party in regard to the solar consent. So part and parcel from the beginning, it's in the council's mind that this is part of the consent process. Going up onto the bottom of the page before that, you see I explained to Mr. Crystal that the clearance appeared to have begun a few days after ECAN had requested the ecological assessment. So that interesting timing was within the council's attention then. We then go up to the next page up. You see in these emails there's a bit of bouncing back and forth at this stage between planning and compliance teams within the council. But then we see an email from Sean Quinn of the 29th of April to me explaining that the information about the clearance has been forwarded to the planner processing the solar farm consent. And just to finish off the circle, if you go then all the way up to the first email in the chain, which is up several pages, on page 10, you have what was ultimately Sean Quinn's last email on the subject to me, explaining in the second paragraph there that there is currently a resource consent application in for a proposed solar farm on the site. Through this consent, the council will continue to work with the landowner and applicant to protect and enhance biodiversity on the site. So you can see, says, it's plain from the get-go that this was going to be dealt with through this consenting process. I will just, while you have that email up, because it's probably the best time to say it, just put a marker down for something I'm going to return to later in the week, that this does portray perhaps a troubling closed-mindedness on the part of the council, because obviously it can only be dealt with through the consent application if consent is granted. There seems to be closed-mindedness here to the possibility that consent might not be granted. But as I said, that's a point I'll come on to when I address you later in the week. And of course, that whole position does accord with what Ms. Kirby explains in her section 42A report at 62. You also have in the bundle of documents we've provided the straightforward evidence of Mr. Harris, who explains that the farm manager told him that the clearance would be done because of the solar farm. So as my preliminary submission is, you can end it there. The application doesn't change any of that factual matrix. It doesn't unwind the clock. Whether the amendment is allowed or not doesn't change the position. But when the clearance occurred, it was within the scope of the application. And it was necessary for the application to proceed, as you yourself, sirs, have noted. Effectively, my primary submission is that the amendment application doesn't change things one way or the other. Having said that, obviously, most of the discussion you've heard so far this morning has been about the amendment application. So I will address that. First, I think I need to clarify something that you heard from Ms. Labas. The thrust of her submission this morning was very much says that this change was made to respond to concerns raised by submitters, and that is a perfectly normal and responsible thing for an applicant to do. Unfortunately, in this case, when it comes to the clearance and the amendment, that submission actually conflicts with the evidence of her client, because Ms. Alakamil tells us outright in her supplementary witness statement at paragraph 6 to 7, I'll quote, "Minute 8 has provided further insight into the hearing commissioner's procedural concerns regarding the relationship between the unconsented clearance and the scope of the application. To resolve this issue and remove any ambiguity regarding the scope, the applicant has instructed its legal counsel to formally refine the boundaries of the proposal. The amendment is not a response to concerns raised by submitters. Indeed, if it had been, you would wonder why it was only raised at this point. It is a direct response to the procedural issue that has been raised as to whether or not you need to deal with this as a non-complying activity.
Can I just ask you a question here? Could it be that the council should have taken enforcement action at the beginning? Is that the answer to the question? And that they themselves have got the process wrong?
It may have been open to the council to deal with it that way. That would have had to be a decision that it would take at the time. But you see that there was no requirement that it do so because it is within the scope of the present application. It would be artificial to say, go away and do another consent application when it's squarely already within the scope of this one.
But at the time I'm just looking through your emails, and I understand what you're saying at the end there from Mr. Quinn, but he is the compliance officer. What he was dealing with initially was the fact that there was no consent to undertake an activity which had already been undertaken. So effectively, it becomes an enforcement issue, doesn't it?
It may have been open to the council to deal with it that way at the time, but it chose not to. So it chose to deal with it through this process.
And that's what I'm asking, is that an error to deal with it through this process? Because it already had that before it. The process was already before it.
So this process was already...
No, the
Yes.
fact that a complaint had been laid and they had acknowledged that there was a need for it to be addressed, and therefore they had an enforcement process underway.
So I think, so I think there are two parts to that question, if I may. I think the first is whether the council lawfully could choose to deal with it either as a separate enforcement action or through this process. And I think the council has broad discretion how it deals with these things. Yes, it could choose to deal with it through this process. And the second part is, did it, or did it in fact deal with it as a compliance issue? And I'd say it's clear certainly from Ms. Kirby's Section 42 report that it chose to deal with it through this process. Indeed, we also know from the Section 42A report that the council still has not made a determination of whether or not this activity of the clearance was a non-complying or restricted discretionary activity. It would be surprising, to say the least, to think that it had engaged in an enforcement case, reached a decision on an enforcement basis without even determining the preliminary question of the status of the activity that had been done. Prior to your questions, I was just dealing with Ms. Alacarmel's evidence. The other point I'll make about her supplementary witness statement on this is that she explains at paragraph 10 that what the effect of this amendment means is not just that you remove it from the scope, but that the planting the applicant is now intending to do must be regarded as purely ecological enhancement and not as compensation. That is the applicant's evidence as to what effect this amendment would have. And I say, sir, certainly surely that is an artificial and unconscionable result on any level. Now, there's been a lot of discussion about the Amuri case. I don't know if you're familiar with it, sirs. I did include it in a short bundle.
Yep.
I don't know whether it helps if I take you through it, but I can give you the brief facts if you're not aware of them. As Ms. Silcott explained, it was a different context. And that's not surprising because rightly and thankfully, abusive process cases especially in the RMA context are rare. And so you are very unlikely to find two cases that are fully square on the factual basis. That's a point recognised by Judge Jackson in Amuri itself, there had been a consent decision there, then an appeal, and then a memorandum was agreed among the parties, and then the appeal was withdrawn. So it was quite specific and unusual factual matrix. The procedural question was whether leave was required to appeal, or whether leave was required to withdraw the appeal, or whether withdrawing the appeal would be an abusive process. So although the facts are different, sir, it is quite analogous to this case in this sense. Normally, as is recognised in the Amuri case, no leave is required to withdraw an appeal before a decision is reached. That is the general principle. Just as here, the general principle is that if you seek to amend an application, provided you stay within the limits of reducing its effects, no leave is required. We have an analogous situation then in Amuri and in here. A general rule that no leave is required, but a specific and unusual factual matrix which may require you to set aside the general rule. Ms. Labas and Ms. Silcott have both presented that principle that no leave is required to amend so long as you are reducing effects as a hard line that you cannot look behind. The Amuri case tells us that is not so. Just as the general principle that you do not need leave to withdraw an appeal can be set aside if the factual situation warrants it, so too can the general principle set out in the HIL case that you do not need leave to amend. There are circumstances when you do need leave to amend, and particularly where it would be an abusive process to allow the amendment. Says, it's set out in my written submissions, and as I say, we've given you the Amuri case as well. Its discussion of the abusive process concept is quite detailed and thorough, and I say particularly helpful. Judge Jackson begins with a comment from Lord Diplock in the English case of Hunter, and that's to the effect that misuse of a court's procedure, abusive process is where there is misuse of a court's procedures that would bring the administration of justice into disrepute among right-thinking people. And in the Amuri context, Judge Jackson noted that the potential abuse there is in the undermining of confidence in the administration of the RMA. Now, sirs, I'm in your hands. As I say, Amuri is in the bundle. I can take you through to it and go through it in more length if that would be helpful. I'll be guided by you.
Yeah, I've read it through, so it's fine. No, I don't think you need to take us through. I think we've got the gist of what you're saying, and we've both read it through. So
Says one final point. Says, I say the factual matrix is such, and as the point I've made in my written submissions, that it would be unconscionable and it would undermine the confidence of the Resource Management Act to allow an amendment in these circumstances. And indeed, says, I say, it's obvious that this should not be allowed because consider the consequences. If this were permissible, it would allow an applicant to escape the scrutiny of the Act and choose whether it would rather risk a fine or risk consequences for its application as a whole. Fines, at least at the time, for clearance of Indigenous vegetation are in the order of the tens of thousands. Now, of course, that's a significant amount of money. But in this case, the applicant tells us that over $1 million will be spent on plants alone. In this case, it is a drop in the ocean. There may well be cases, sirs, and this may well be one of them, where an applicant would happily take the risk of a comparatively small fine if it makes it easier to obtain consent. So as I say, the RMA cannot be so exploited. And to make it clear, sirs, this isn't just about whether it's a non-complying state activity or not, although that, in terms of the consenting process, is in itself a significant issue. It also has potential consequences when you come on to consider the provisions of the National Policy Statement on Renewable Energy Generation. There are, says, considerable consequences to the consenting process that turn on this issue. And in these circumstances, it is squarely in the court, in the territory discussed in the Amuri case. Much of what you heard this morning from Ms. Labas and Ms. Silcott was that the change would reduce the adverse effects of the application. Of course, what it does is remove from the scope one major significant adverse effect, the clearance of a significant area of Indigenous vegetation. One final point that Ms. Labas raised, sirs, was that this was done by the landowner without the applicant's knowledge. Well, sirs, there are three problems with that submission. The first is a factual one, and it's timing. You'll recall the ECAM letter I referred to. The clearance took place 1 week after the applicant, not the landowner, was told that an ecological assessment would be needed. And I won't turn to it now, but you'll see in our written submissions on the activity status, there is an issue of whose evidence is to be preferred in respect of Mr. Kidmer. So that needs to be borne in mind. You have Ms. Alacarmel's evidence that she prepared the assessment of environmental effects. Why was the issue of the Matagari not identified? At that stage, it is a significant area of Indigenous vegetation that has as I say, its existence has far-reaching consequences for how this application goes forward. And in addition, it says, if the applicant were confident that the answer to this is to say, well, it was the landowner and not us who did it, and that resolves the point, why are we discussing this present amendment? And finally, so again, that approach would simply open the RMA up to abuse, because an applicant would only need to outsource unlawful activity to escape the consequences. I think, sirs, it's important to remember on this point that this problem, the question of the Indigenous vegetation, is a creation of the applicants on two fronts. First, because it chose a site to build a solar plant that held a significant area of Indigenous vegetation. That is the crux of the issue, and they are now seeking to avoid the consequences of what we may say was poor site selection. Second, it is a creation of the applicants because it was not identified by Ms. Alacarmel in their own application. That is the crux of the problem. As I raised in my written submissions, two other issues. One, as to the evidence of Ms. Alacarmel, and secondly, we gave our initial submissions on activity status. I don't propose to address those now unless you indicate you'd like to hear from me on them. But again, I'm in your hands.
No, I don't think we need to at the moment. I think we're just dealing with this issue at the moment.
So I guess where you're pointing us to is that this procedural matter or issue means that the only decision we can make is to decline the application or not proceed with the application. Is that
with the application as a whole?
Yeah.
Or, no, so I'm not submitting at this stage that this means you decline with the application as a whole at all. I'm saying you should decline the application to amend.
Right.
Either on the basis that it, well, primarily I say it doesn't actually have much effect because the issue of the Matagari remains within the scope of the application in terms of considering activity status, in terms of considering the environmental significance of the site and then the assessment of environmental effects, and in terms of considering what the effects of the activity would be. And that's because this application to amend has happened after it took place. When it happened, it was within scope. You can't unwind the clock in that way. If you're not with me on that, then I say you can't, the only appropriate course is to not allow the amendment application, because it would be an abuse in this admittedly very unusual factual circumstances, but I say quite analogous to Amuri in that sense that you have an unusual and unfortunate set of facts. And that displaces what I accept is the general principle as to modification. It is not set in stone. It can be displaced, and this is a prime example of where it should be.
Yeah. And so one option for the applicant still remains is to withdraw the application as a whole and resubmit.
Unfortunately, so yes.
Yeah.
And which I think is not a scenario anyone would want, let alone this community who have been living with this for over 2 years now. The other thing on that I would flag, sir, is this has been known by the applicant for over 2 years. What are they going to achieve in any more time that they haven't already?
Okay.
I think what you're telling us is that we should continue to consider. We can't stop them withdrawing a component of their application. That's the applicant's choice. What you're asking us is to continue to consider the issues associated with the Matagari removal within the site, even if there are no solar panels over that area, correct?
Yes, absolutely. To be clear, you can't require the applicant to build solar panels on that bit of site, and nor did you. Indeed, if you permit, even if you, so 2 points, I suppose, is that I think we get to the same place through different routes. You either say it doesn't make the application to amend doesn't make any difference. Or I say you said, sir, I think you can't require an applicant to continue with an application if it wants to withdraw it. We're talking here about a modification of the application. And I say you can say that legally, in terms of your analysis, you don't allow them to make that modification because it would be an abusive process. And that's the Amuri principle. If you do that, that of course doesn't mean that they are then forced to build solar panels on that part of the site. They are free to choose not to. So there is no prejudice to them in that way.
You're not saying that we shouldn't continue with this hearing?
No, sirs. Procedurally, you may consider it helpful or sensible to deal with it as a preliminary issue because it does affect the legal lens that you look at the rest of the application in, whether we're going through the section 104D higher threshold test, whether that's the applicable test, or whether and that's what would apply if it was a non-complying activity. You may, sirs, find it helpful to have a view on that before you hear the evidence. That, of course, is a matter for you.
So if we were to continue on the basis that we don't allow the removal of that section, as you are suggesting, then we have the situation where the applicant has not provided an assessment of part of that application because they haven't provided an assessment of the clearance of Matagari.
They haven't provided any evidence on the subject, sir.
So we would need to obtain that evidence.
Well, says in my written submissions on the point, we've gone through and we've provided evidence on this point ourselves.
Correct.
In the supplementary bundle. You will see it is not actually a difficult subject. I don't want to suggest this is the decision on whether or not the clearance was non-complying activity or not is very straightforward. The evidence is very clear, and indeed, I don't understand there to be any serious dispute about it. If there was, why is this application being made in the first place? Also, sir, on that, I'd say the applicant has known this has been an issue. As I say, from 2 years when it happened, it was raised in many of the submissions in August of last year. If it wanted to adduce evidence on this point, it has had every opportunity to do so. I don't suggest, sir, there's any need to allow enough further extension of time to do what could have been done, and yes, for 2 years.
I think the reality is that we would only be dealing with section 104D in any event. The Matagari's been cleared. There's nothing for us to see there in that regard. So then all we're then left with is 104D of the Act, and whether this is non-complying, and therefore does it fall under 104D.
Are you saying absent if we take the Matagari issue out of the?
No.
Sorry.
Sorry, in terms of the effects assessment, it's not there. It's gone.
No.
It's been taken away. So there's no assessment as to whether or not it should be retained or anything like that, because it has been cut. So the question then becomes, does it meet the 5,000 square metre test to go to non-compliant? If we consider that to be appropriate, and therefore brings into play the section 104D test.
Yes, if you're happy that the area was greater than 5,000 square metres, and you'll see, sir, in the evidence we've provided, there's a Dr. Merck, who's an ecologist, who's done a very straightforward analysis, and he's very clear in his evidence that it's well over the 5,000, more likely a hectare. As I say, there's not a serious factual dispute around this. So factually, I say, so it's clear it is a non-complying activity. That puts you in section 104D territory, yes.
And that becomes the primary issue, doesn't it?
Yes.
Yeah.
I should say, Sarah, on your question just then, of course, it also, as well as activity status, it will affect your consideration of the existing environment, because the existing environment will have to have been taken to include the indigenous vegetation, and it will affect your assessment of the environmental effects, particularly in the context of offsetting. In this case, is becoming very important. The restoration planting that the applicant is proposing. This is the point made in Ms. Alacarmel's supplementary witness statement. If you take the Matagari issue out, she is suggesting you consider the restoration planting as purely net ecological benefit, if you like, and not as offset or compensation for what has been cleared. So it becomes, stays within your assessment on 3 separate fronts.
Okay, thank you.
Thank you.
Thank you. Joanne's cool.
We might take morning tea now, because it's 10:15 before we get in there. I just see we have a bird flying around here as well.
Yeah.
Liz, how do you deal with birds inside? Okay.
Thank you, Commissioners. As flagged just before the morning tea adjournment, there were 2 very short points I wish to make on behalf of the applicant. The applicant agrees with council that the scope of the resource consent application lodged did not and cannot now incorporate an activity, i.e. the clearance of indigenous vegetation, that was not assessed and addressed in that application. That is why the commissioners were quite right to put the applicant on notice that unless the issue was squared up to, section 90 would have to come into play. So I do agree with my learned friend, Ms. Silcock, that the application, even as amended, can't doesn't give the commissioners scope. The other point I wish to make in reply is that to advocate a proposition where an applicant who is not otherwise resident on and working their application site every day, to make that applicant responsible for the actions of third parties without its knowledge or direction would create an absurdity and a potential danger for all applicants that they could be subsequently held responsible in law for the unauthorised activities of third persons. That is an absolute absurdity. But it is essentially the facts that did lead to the applicant, with the assistance of legal counsel, making the decision to amend the application by withdrawing that area of land which the landowner himself unilaterally had cleared of Indigenous vegetation without the applicant's knowledge. You have the evidence from the landowner, the person who undertook the vegetation before you. You have not asked him to appear for questions. That evidence constitutes the best evidence available to the council, and I've already outlined this morning what Mr. Kidner now proposes to do to rectify his compliance with the district plan. Those are the only two matters I wish to raise before calling our first expert witness.
Can I just clarify that first point that you're making? You're
Yes.
saying that the applicant agrees with council, I'm assuming council from the
Council.
Yep, that the scope of the resource consent cannot be amended to include the removal of vegetation because it didn't.
No.
And you're saying because it didn't include that.
From the outset, because
Yep.
the applicant didn't know. It does not reside on the site. It does not work the land. It has occasionally, through a variety of expert witnesses and company representatives, flown in and walked the site every few months. It doesn't have the intimate, detailed knowledge of what the landowner has been doing. To suggest otherwise is absurd, but what we do have is, as I said at the outset, some missed opportunities by both applicant and council to address the matter in a timely fashion. As a result, we are here now. The applicant made a decision just over a week ago to remove the issue from this hearing to avoid what would have been an appropriate Section 90 decision. But it is certainly incorrect in law for Ms. Kelsey to state that there is sufficient scope in the application as lodged to deal with this matter. There isn't, and I absolutely agree with my learned friend on that, which is presumably why the commissioners yourselves identified Section 91, sorry.
I think one of the points that Ms. Kelsey was directing us to was the timing.
Yes.
And I do have a question for Mr. Cocker about this later.
Yes.
The policy in question is in Mr. Cocker's original assessment and a photograph of that Matagauri.
Yes.
So are you also able to say for the applicant that you, as an applicant as a whole, it was known that it was there, the policy was known that it was there, but it was missed through the application?
The evidence I have before me and the answers to my questions to the applicant team is that they did not realise the landowner had cleared the vegetation.
No, that wasn't quite my question. It was prior to that.
Mhm.
The application would have required consent for the clearance. I think that's now clear because that's why the section has been removed and we can't add
Yes.
that part of the application in.
Mhm.
But the applicant as a whole, through its experts, knew that the Matagauri was there and that the policy existed
That
because it's in Mr. Cocker's original assessment.
I would invite the commissioners to ask the experts. I don't have that information. I'm simply aware that the regional council process commenced. That was the context in which the ecological report was required, not this district council application process. And there seems to have been an overlapping at some point of experts being on site before and after clearance, but not necessarily the same experts. But that's as far as I can take it as council.
I'll direct it to Mr. Cocker.
Okay.
Thank you. The applicant would now like to call its first expert witness, or company witness more properly, Mr. John Andrews.
Just before we do that, I'm just in terms of your original lead. So, Mr. Andrews, you're right, you can sit there. We can come back to this. We may well have some questions on your original legal submissions beyond the issue that we've just dealt with.
Yes.
So I'm happy we're going to do that now, or you can leave that to later on. That's up to you.
I'm completely in your hands.
Okay. Can we deal with those first? I'd just like to deal with those legal questions we've got on your legal submission. So this goes beyond the issue that we used procedural matter where we've just been dealing with. So I just wanted to ask you some questions around the legal submissions, and in particular, I just want to talk a little bit about the NPS REG.
Yes.
So you might just want to.
Yes.
So you've directed us to policy C.
Yes.
But I want to take you back to policies A and B. And in particular, at the beginning of the year, we had a number of changes, one of which was to change the shalls to musts in those two policies.
Yes.
So from a legal perspective, what in your view does that mean for our considerations, the moving from a shall to a must?
They are mandatory.
So they are more mandatory than they were. Is that there's that move from shall to
Musts are pretty interchangeable.
Yes.
For laypersons. There is a bit of statutory evolution in terms of drafting principles that try and make the intention of statutory provisions clearer. And the current practice or protocol is to remove shall and replace it with must, so there is no ambiguity as to the mandatory nature of that statutory provision.
And I guess that this may be addressed by the planners later on, but there's a number, particularly in policy A, there's a number of new.
Can I just get my laptop?
Yeah, just.
I have everything on my desktop here. Carry on, I'll catch up.
So in policy A, there's a number of new, let's call them criteria, added in January.
Yes, this year.
Yep. And I'm just wondering what your take on those additions? I can, do you want me to run through them, that make it easy?
No, I'll just grab it from my desktop. Here we go. The old version.
You know, you don't want the old version.
No, here we go. Got the old and the new, just to be safe. Policy A, right, I'm with you.
So in policy A, we've now got a number of criteria, A to H.
Yes.
And again, there's been a number of amendments in there and additions, I guess, is probably what I'm more interested in. And I just wanted your take on those and where that takes us in terms of the REG.
Certainly. These have been promulgated by government deliberately to enable and encourage renewable energy generation in response to a number of experiences of gentailers finding the traditional decision-making criteria under the RMA as not entirely facilitating the growth of renewable energy generation that successive governments have wanted to achieve in order to reduce reliance on hydro in this country. And so this is a deliberate policy to assist decision makers to expand their discretion beyond a traditional Section 104 decision-making framework that was drafted 30-something, well, actually probably about 35 years ago when you consider the timing of the Resource Management Bill back in the day, that simply didn't envisage the importance of renewable energy generation in New Zealand. And so this, as a national policy statement, sits straight under the Act and is, according to government, going to give decision makers a better chance of actually looking at all the pros and cons of trying to grow the renewable energy sector in this country and remove or reduce reliance on hydro.
Okay. The other question I've got for you is in relation to policy F, which is obviously a new policy, and the use of the words where practicable.
Yes.
And in relation to avoid, remedy, or mitigate.
Yes. Again.
Is that deliberate?
Very. It is reflective of the fact that we have had a number of applications and decisions, even in the court on appeal, where the early proponents of renewable energy, whether that was wind, solar, even geothermal, have struggled to get their projects through the traditional Section 104 framework and the district and regional plans that give effect to the RMA, particularly where there was scientific or technical uncertainty in early days as to whether effects could be sufficiently avoided, remedied, or mitigated. So the where practicable is a deliberate choice of government.
So in considering effects and with the avoid, remedy, or mitigate requirement, where does where practical take us in terms of that consideration? Because it doesn't sit in.
It doesn't sit in the RMA.
No.
No, and it is deliberate, and in my own view.
So if we consider, so what I'm trying to get at, if we're considering the avoid, remedy and mitigate criteria from section 5, we've now got a where practical sitting in front of that in terms of the next higher order document dropping down.
Correct.
So where does that take us in terms of our decision making, that where practical in relation to avoid, remedy and mitigate?
You have the permission through the national policy statement to employ that holy trinity, if you like, of effects management, but you don't have to be as slavish about it as previously. If it is not practicable to avoid, remedy or mitigate an effect, you have a gateway nevertheless to exercise your decision-making discretion to approve a consent, to impose conditions that get as near as current science or knowledge allow to address effects, but you don't have to simply default to a decline, which arguably did happen previously. Even some of the Environment Court decisions, and I'm thinking of the wind energy, a wind farm decision in Meridian. Back in the day, that created a lot of discussion. There were significant effects, significant landscape effects with that proposal, but the court nevertheless weighed up the pros and cons, but took on board the incredible importance in this country of diversifying our generation sources, and nevertheless did approve the consent. There is nothing in the RMA, and it's largely an urban myth, quite frankly, that has evolved over time. But there is nothing in the RMA that prevents decision makers granting consent for proposals that have significant effects on the environment. There is no such prohibition in law. And this, where practicable, is very much in keeping with that thinking. Some things, particularly essential public works and infrastructure, network utilities, are so important to the community and to national well-being that they do deserve consideration, despite their adverse effects.
Okay. I should say, Ms. Silcock, if you want to address this stuff later on, Councillor, it's up to you, that you can. The next question, you've led me into my next question. This relates to the you've indicated that the proposed solar farm will not be significant, the effects will not be significant. However, Mr. Cocker's assessment in Appendix B reaches a conclusion of high visual effects in the 0 to 5 years. My understanding, and I'm sure my learned colleague here will correct me,
That's no question.
high, all right, excellent. That high under the 7-point scale is equivalent to significant. So that it raises the question of clause 6.1a and the fourth schedule. Now, I accept that he is saying in 0 to 5 years, but wouldn't that trigger? Wouldn't that trigger that assessment?
No, I would advocate it doesn't. I recall that Mr. Coker frames his expert opinion as moderate to high.
Now, this is particularly high in relation to some certain properties.
Oh, okay. Understood. No, because the temporal aspect has to be considered when you are looking at effects, and that goes back to the definition in section 3 of the Act. The fact that the effect is for a comparatively short period of time when considered across the 35-year life of a solar farm and will reduce to low to negligible once landscape planting is established, is very important context to consider.
So what you're saying is that the 0 to 5 period that he states that it would be high needs to be taken into
The round.
in the round in relation to the 35-year consent. Yeah. Which leads me on to another question around the 35-year consent. What is the purpose of a 35-year consent?
That is tied up and aligns with the occupation of the site. Far North Solar Farm doesn't own the site. It is going to occupy the site through a lease agreement. I'm not privy.
So it's something at the 35-year period is something that the applicant's actually offering up.
Correct.
Because
Otherwise, you would not normally have an expiry date. Correct. Correct.
Right.
But it has a commercial origin in terms of the negotiated occupation of the site with the landowner.
So question I've got.
I think you actually asked my question, so,
sorry.
well,
Apologies.
no, that's good.
Okay, thank you. Welcome, Mr. Andrews. Now, we're happy if you were to summarise your evidence, and then I suspect we've both likely got, we haven't actually conferred if we've got I've got what I have, and your Ray has. So happy for you to summarise your evidence, and then we'll go through any questions that we have.
Thank you. Good morning, Commissioners. John Andrews Zaho. I work for Far North Solar Farm. I'm the General Manager, which means I look after the front end of the projects from site identification through to taking them to ready to build. This project was very carefully selected and has been chosen as a suitable site out of a large number of sites that we evaluated in the North Canterbury region. And we've done this as part of our program of identifying sites throughout and across New Zealand. The big beauty of the site we considered was the flatness, the higher radiance, the short connection to the grid, and it's a good point with spare capacity, and that the land being flat did not require any major earthworks, and we weren't competing with major or highly valuable other activities or other land uses such as, say, dairy or viticulture or something like that. So it was being dry stock made the economics for the farmer suitable. The design did evolve over time, and that was based on feedback from neighbours and from submissions and from discussions with the landowner and our experience at other solar farms as they went through the consenting process. And that made us do a major redesign based on the feedback of those factors. And that was at the with the permission of the land farm of the farmer, because it changed in some ways the way he would be able to farm and operate between the solar arrays. The project has always been designed as a dual-use farm with solar. We have some sites where the sheep use to cut the grass. This is not. This is a farm that will have solar on it, and that's how the landowner sees it. And we've worked with him to ensure that it is a farm with solar on it. The power from the project will be distributed firstly into the local grid, then nationally, and will probably flow north into the Marlborough and West Coast regions. Transpower have major concerns about the growth of load in those regions and the lack of additional generation, and this is a project that will help address that problem. right from the beginning, we've wanted to mitigate the solar farm. So we've always planned to plant screening around the boundaries of the site, try to mitigate it in those types of ways, try to move any sources of noise away from neighbours, away from sensitive locations. We've also taken the opportunity to find areas where we could do native enhancements. In this area where it's pointed out to us that there's not a lot of this landscape that is left, and it would be good that we could use the slopes that the farmer didn't have a lot of value in his mind. We could use those to revegetate and enhance the vegetation that would have been there in ancient times. And being by a state highway, we also considered that quite an advantage to us because it generates an alternative source of noise. So we're not like we're moving into a pristine environment in any manner. Consultation has been in many directions over a very long time, including, for iwi down through Hapu, all the lines companies, power companies, Transpower, and through FENZ, NZTA, and the council. In economic terms, the solar farm is a very good financial proposition for the developers. It's also a good economic impact into the area, with a large percentage of the funding being spent locally in the region. And then long term, the land will continue to be farmed, and it will also have the additional economic impacts or benefits of local employment for a lot of the services that will happen on the solar farm over the next 30 years. And that'll be a fairly low flat line with the occasional burst of activity at certain times during the solar farm's life. Overall, I think this is one of our better projects, and it's probably one of the better projects around in terms of good connection, flat land, and in an area which is not hugely overlooked. There's being on a plane, pretty much everybody's at the same level, and there's not housing on the hillsides around it looking down on it, as some other projects we've seen around New Zealand are. So that's the summary of my evidence. Happy to answer your questions. Okay.
I wanted to ask you how's the solar farm going to be connected to the substation? Because that consent hasn't been applied for, so I'm assuming that there'll be some connection somehow. How does that occur?
Yep. So at the moment, when we started out, we were working with main power, and we were going to connect via main power, and then that line would be done under their utility status. Currently doing more likely be connecting via Transpower, and it will be that they will work with them and they will do the connection back to our site.
Right.
So does that mean a new line that they will consent?
It could be new wires on new poles, or it could be wires on existing poles. Yes, it'll be some new copper between us and the substation. Yes.
Okay. So they could use their existing towers.
Yes.
Or designations?
Or
And through their designation.
Through their own designation.
and easements.
Yep.
The landowner actually owns all the land across the river and up towards past that dam, almost to the substation. So he actually has ownership, except for the last bit over the railway and road.
And is that substation that you would be?
Yeah, we're going to the Transpower. It's a grid. It's actually a grid exit point, and it will become a grid injection point, or both.
Yeah.
We're not going to the Mackenzie Road substation further down on the corner. We're going to the Transpower grid point, which is the same place that Mount Cass is going to.
Can you show me that? Sorry, can we just get a map? Can you just give me that? Sorry, I want to make sure I got that right. I've got your site map.
So in my Appendix A, which is version, yes. Yep. I think if you go to the sheet 4 of 5.
The red.
This red square down here.
Okay.
That's our if we need a switch yard, that's where all the wires come together basically. And that will go to a switch and then it will go off-site from that point.
Okay,
And there's already 3 sets of transmission lines going across. Some of those have easements, some of them don't. But we would find a route across through one of those easements, or the utility would do that back to GXP across the road, across the river and across the road.
okay. And so we don't know what that looks like at that stage, what's in that red box.
Inside that red box will probably be fairly small cabinetry, this size of half a container maybe. It's called a combining unit. So what it is all the individual electronics on the site. They come together at 33 kV, and then that can go just onto one set of wires, which would then go through a breaker. And it would go across and that breaker would be our point of demarcation, where we finish and the lines company or the utility starts, and they would take it back to the switchyard.
So they would take it back at 33 kV.
Seems like that's what they're discussing, and it looks like they would want to do the transformer on their own land under their own business.
To step up to 110 or 220.
220 kV, yeah, yes.
You indicated that the Mount Cass wind farm was going to install transmission lines across the site as well.
Yep.
Do you know where they go?
Yep, they've got an easement. It's been there the whole time. The easement wasn't quite where we thought it was, so we've just recently had a very minor shuffle, and they
does that line up on
it's not it. See it? No, we haven't shown it on these. We just don't have panels in the area which are off our site.
So does it come in at the bottom of the site?
Yes, so if you go to the last sheet of the page on the very bottom of the site, it basically cuts through up here along the river bank. It's on the title, but it's outside of the solar farm area, and we just slightly wiggled things around.
And does that then turn and
90 degrees.
90 degrees and follow the other lines as well?
Yes. And at that stage, Mount Cass was on hold, and that's why that was our intended point of connection. But Mount Cass is alive again, which is good. And they're taking up the easement, we believe.
And so they don't have switching gear on your site. They're just
No, they're just
the lines.
They're just turning 90 degrees. So
and it goes to the
quite a solid bit of physical there to turn to cross the river through that easement.
So you end up with 5 lines running through the site.
There's 3 down here, and there's already one up
Further up
the other end going over.
The Mount Cass one would be another one.
Yeah, and it will come up and join this easement and come across. It'll join probably the main power easement, not the trans power.
Right. And the main power one is the bottom one.
I honestly can't remember. I thought it was the middle one, but sorry.
Maybe the middle.
That's written.
And all that goes into the Transpower substation.
Yes, it goes into different parts of the Transpower substation, but yep, different voltages.
And I just wanted to clarify that you referred to in your paragraph 61 to losses in lines. Can I take it that what you're meaning is electricity losses?
Yes. But of course, electricity losses are financial and ecological losses.
Okay. At your 100, you talk about your discussion with Mana Whenua. Can you give me an elaboration on where you're at with mana whenua, and there's no cultural values assessment, I'm assuming, no. So where have you got to with mana whenua?
So we started out quite early on. We visited Ngātahu in Christchurch, and they said, really, this is not of interest to us. Talk to mana whenua or local hapus. So we did contact a number of local hapus. I wasn't running that program, but we had very little interest or feedback. We've we've made multiple contacts with them. The most recent chain of engagement has been with the Whatuaroa Centre, who are the Runanga office, local hapu. And it's been very much that they would like to work us through procurement and services and work like that. So the entire engagement has been about that. And we're a little bit surprised about that, but that's really seems to be their thinking on it. As we've gone back and we've tried to re-engage, a bit more, they've said, talk to our procurement team, meet you on site, we'll talk to you about the things that we can do together to do procurement work and stuff with them. They've looked at I don't know, I suspect they've looked at our mitigations and see a lot of good value for what they'd like to achieve as well. And they'd like to do it with us. So it's good news.
So that when you're talking about procurement, you're talking about hunting, work,
yes,
involved in the work and installation and that type of thing.
Everything like that. And that's their words, not ours. I mean, we don't. They actually have people we keep getting referred to are in their procurement team, and that's the emails and the phone calls. They keep doing that, which is great because we'd love to work with them. And there's considerable amount of local spend and there's considerable amount of long-term stuff, and it would be great to work with them. That would be part of our values and has been on all our sites. Close working with the local hapu, iwi or marae.
Okay. Just briefly want to just touch on construction noise, which Mr. Ibbitson's going to have a look at, obviously. There's just one thing specific. He mentions a Vermeer PD10 pile driver for putting in the posts. I don't really know how pile drivers work, but can you explain that? So that pushes the posts in rather than hammers them. Is that right?
It looks like they're pushing them. When you see the videos, this looks like they're yes, very small vibration.
Right.
So, and the big surprise to us was that the drive was 40 seconds. It's a post per minute. And you think it's pushing it in, but it's doing vibration and just pushing it straight down.
Right. And you're confident that's going to work for the site on these soils?
Well, I'm not, but the geotech guys are. Yes. Yeah. And they've been there and they've visited. And honestly, they look at it, and it's, as soon as you go there and you look at the land, you realise the type of land it is, and you look on there's a lot of research. And they said, we know exactly what we've got here. Remember that there's a lot of viticulture around here. They know what the ground conditions for pole driving are like. Okay, they were more than confident.
Yeah. When I think of viticulture, I think stony. It's a very difficult soil underground. It might be dusty on the top, but
we're driving C or H beams, not wooden posts.
Yeah. Okay. This may seem like a weird question, and apologies because it actually came from a friend who's an apple orchardist. You are talking about using sheep, and you mentioned, I think, just a second ago that you're using sheep on other places. So you have no problem with the sheep eating the cables, or no issues with the compatibility of sheep? And
no, but you have to know that when you build the solar farm, imagine sheep were goats. They're not, but they're close to it in terms of their interest. So all the cables are cable clipped and cable tied, and everything is held up and out of their way and not given the place like this. Now, this is normal practice in solar anyway, because you can't have wobbling cables even on rooftops of buildings. So everything has to be secure. There's very good examples, and I've referenced certainly the TVNZ article, which is now quite old, of the solar farm near Kaitaia, where the solar shepherds are walking around and there's sheep everywhere. That's just becoming more and more common. It was kind of unusual and people didn't believe us when we first spoke about it 6 years ago, and now it's absolutely standard practice. worldwide, and even in the States and in Australia, they're starting to, before they can, they're putting them at high and putting cattle under solar. In New Zealand, we're not doing that.
No.
Yet it's just, it gets so hard. But sheep are absolutely compatible. But you can't, and that's actually in our agreement with the landowner, the grazing rights very specifically say what they can and can't put in those paddocks.
Yeah. I'm assuming it's going to be a reduced stock rate than normal, but.
That's been a matter of debate. One of the solar farms we went to, they did have trouble, and it's because they didn't have a shade-tolerant grass because there were no trees on the site. They hadn't planted the shade-tolerant grass. Now, one of our other solar farms has got very ancient or very tall windbreaks, so they've really figured out the need to plant shade-tolerant grasses. And what happened at the solar farm in question was they re-drilled it, or they actually top dressed and oversowed, and they converted it to a more shade tolerant, and it's absolutely lush. It looks like, I've got the photograph, I think you've seen it. But they certainly had trouble at first until the realization was made, you need to have the right species planted.
Okay, good. The last question I have actually is really just to help me out, and you mentioned it in your oral submission just shortly, that you have made changes to the proposal as it's gone on, not respecting the removal of that portion. I just wondered, would you mind just really quickly, perhaps just taking through exactly what those changes are? And perhaps it might be easier, I don't know if you have it, if we reference the AEE, the original application, there's a description of the proposal at section 3. Just, yeah, really quickly, what changes were made and approximately when they were made? Shouldn't need to be a big exercise.
I haven't got the AE with me, but in general, when we first looked at the site, we looked at all of the flat land that was available, and the farmer told us, well, it's all in cultivation. You can use whatever you want. You know, I'll work around you. We moved, so we actually went quite a long way down to the south. There was a proposal to have vines in one particular area and things like that, which that block, I believe, has irrigation. So that was partly the logic of that, because the rest of the solar farm doesn't. That was that. And then we looked at the mitigation and visual mitigation in terms of the screening. And we were doing this pretty much what we would consider the optimal way of doing solar, which is relatively widely spaced, but very tall panels. And they tilt quite high, but they're a long way apart. And that was a discussion with the farmer where he would be able to run a drill between the rows and upgrade the seed after 10 or 20 years, you know, because they do re-drill. They possibly would be able to cut between it, but we didn't really think it was a good idea. But he could do a cut through there and make hay, silage, or baleage. And that was the kind of mentality. And then we started realizing that this is quite a big site. We don't want to be high. With the changes in technology and stuff like that, we could lower the solar panels and bring them a little bit closer together, but that would stop all that active farming between the rows. And we spoke to the farmer, he says, I've had a time on the land now, I realise it's not really I'm not going to arable farm between the panels, I'm just going to graze the sheep. So he was happy to lose that. And we moved the solar farm up from the south. We would extend a little bit out because the capacity does go down when you do that. We added a bit more land down on one of the lower flats, so we still didn't go too close to the river. We pretty much compacted it up at that stage. A little bit after, we'd never quite worked out how we were going to do revegetation on the slopes, because it turns out it's an enormous amount of the rises. There's a lot of fencing to do that. So as we talked to him about that, he's kind of didn't mind losing that space, the acreage. And he says, but if you just work out where it is and you're going to have to fence it. So when we added a whole bunch of internal screening, that also made a bit of a change to, you know, got to have space for shading and stuff like that. And then we knew that the slopes below the internal screening, putting a fence along the top, we've got to protect that screening anyway from the sheep. We may as well just run down the hill and run the line down the bottom of that slope. So those are the type of evolution that's happened along the time.
And so that all happened between the application lodging and then the resubmission, as I would call it in was it March 25, I think?
That was, in March 25, most of those things were put in that one.
Yeah.
That was the big change. And it was based on feedback. It was based on our experience.
Yeah.
And a kind of softening of the farmer's attitude towards how intensively he wanted to farm based on his experience.
And that's the 1p to the 2p down to 1p, yeah. And so since March 25, there's no substantial changes since then.
No.
So all of those were
Yeah, the area is much the same.
Yeah.
There was a twist to the alignments.
okay.
And as we were doing our glint and glare studies, we kept getting random little bits of glint and glare, and they weren't major, but they were there.
Mm.
So we moved them, and it's because when they're at a low angle, and the sun is, so if you go north-south and you get those low sun angles, it will go back up.
Yeah.
As if you turn it around and they're getting on towards a bit later in the day, you're still going to get a little bit. So just by twisting at 9 degrees, we lost a little bit of capacity then, because you get all these zigzag shapes up along the boundary. So we'd always align them with the longest boundary to get when you turn at 90 degrees, you just start getting lots of short rows and staggered like that. So there's all those little changes that have happened.
Okay.
And once we moved it to our north-south axis, we can't go back, even though we've later studies had mitigated all the glint and glare and the increased stow angle, got rid of the glint and glare. We can't change it again. So we're happy with that. And it's a nice design from a EPC engine operational point of view. It's not quite so nice from its aesthetics.
So when you say north-south, the panels face east and the morning face west, and
Yes.
yes,
Yeah. The axis that they all twist on is now true north-south.
true north-south.
Yep.
Okay, that's me, thanks.
I've just got a couple more questions for you. I just want you to explain this difference between a solar heat island and an urban heat island.
Sure. So urban heat island is quite a well-known effect, and I studied at university when I was doing environmental subjects. So it was the phenomenon where big cities like London had no snow, whereas all the countryside around them had snow, and they're trying to work out in Europe and why they were doing this. And they finally figured out it's due to the thermal mass, it's the increased amount of dark material, concrete roofs, paving roads, and they become warmer and they maintain that warmth for a lot longer. So that was called heat island effect. Now it's called urban heat island effect. People have taken that analogy and moved, which is basically due to the colour and thermal mass. People have taken that analogy and moved across onto solar heat island effect. They said these panels are going to get hot and they're going to cause everything around there to quote one, basically burn. They're completely different effects. Solar panels are very, very light. Yes, they do become hot when they're in the middle of the day or during the day when they've got intensity on there. They take 20% of the energy of the sun out as electricity. So you've lost 20% of your energy to start with. But the panel does rise in temperature as it does that. So airflow across the panel, you can detect warm air flowing over the panel. And if you were to measure at 2.8 meters, 2 meters, the air temperature, and you were to measure at 4 meters, you would find that there's warm air flowing off the panels. But with the mixing and stuff like this, by the time you get to boundaries, it's gone. And as soon as the sun goes past the meridian and starts coming down again, there's nowhere near the intensity anymore, and the effect disappears. By the time it comes to evening, the panels are at air temperature again. This is not the solar. So it's people extrapolating, I believe it's people extrapolating from one true and well-known effect and multiplying it across. Now they've done every now and again to find a report that finds this aspect, but it's very hard to take like for like. So they might measure solar panels which are in a car park in one particular experiment compared to the open desert nearby. And they found the heat island effect. And it's like, well, you guys, you've got solar panels over a car park. We've got solar panels over grass vegetation. You don't find these effects. You can measure warmer air, and that makes perfect sense. You get it off the side of your roof. That's not the same as, there's no true heat island effect happening.
The next question is around the components within solar panels and this issue around contamination.
Yes.
So like you sort of just take us through that from where it's come to where we are now.
Sure. So one of the problems is that there are solar panels that do contain materials that you really wouldn't want on the ground. But they're not the normal everyday solar panels that are in mass production and are used and are made by the, gigawatts per month. You just couldn't use those types of but they are the very, very high performance ones that they did use in the early days, and they do use in places like space and other things. But 99 point something % of solar panels are crystalline, polycrystalline or monocrystalline. They're doped with the chemicals. So the chemical that it goes into the silicon is bonded inside the silicon wafer, the same way that a transistor or integrated circuit works. It is the same stuff. So there's pure silicon with a very tiny percentage of different metals in there. And some of those metals in there, elements, in there, that could be considered toxic, but they're locked in the crystalline structure. So the silicon crystal, the actual active element is then sealed within glass. So there's encapsulation of glass, and our panels, which are bifacial, there's glass on the front and the back. And that glass is then grooved and is coated with anti-reflective materials. Now, the anti-reflective materials are all sorts of things, but they're shorter than the wavelengths of light. They're extremely thin, and they basically make it like a polarized sunglass that it tries not to reflect, but they're very, very fine. So any chemicals that are there, so the other things are, of course, the solder and the conductors inside the array. So there's a very small amount of solder that has to join all the little copper connectors onto the silicon to get the electricity in and out. We used to use lead solder. They don't use lead solder anymore, but there's a tiny bit of silver in there. There's a tiny bit of copper, and some of those wires are either silver or copper, and they're soldered. So there's all these things in there that people worry about. And then you encapsulate it in 2 layers of glass, and you put an aluminium frame around the outside. If you were to break the panel, first of all, if you broke the panel, we'd probably notice it in a visual inspection, because it would probably cause heat spots, because of the pressure of the break would cause it to flex and would create a hot spot, which we would detect in our thermal imaging all the time. We would remove it. People are hypothesizing that water would get in there and would etch some of those chemicals out and drip onto the ground. I don't really think so. We're not seeing that in rooftop solar, and we're seeing plenty of rooftop solar on people's houses who drink the water, use it for water collection. There's gigawatts of solar installed around the world, and people have been looking for these effects. Now, not every country looks as hard as every other country, I'll agree. But in Europe and in the Western world, we wouldn't allow things which were considered to be that harmful to people, humans, or ground, or anything like that, or animals. We just wouldn't be allowing it. We're well past the scaremongering about the dangers of solar panels. They're an accepted standard technology, and in some societies which have a lot higher ecological values and environmental values than we have in New Zealand, and I mean in particular in Europe, where they're extremely strict on this stuff. You have to meet the international standards. The Chinese wouldn't be able to sell their panels if they didn't, and they do. And we're well past that, I believe.
So I just want to talk about the water issue.
Irrigation.
Yep. Now, I know you've got Mr. Bubb coming along, and we obviously may have some questions for him as well. But I just want to understand, and I accept he's gone through in some detail about the consenting process that's necessary. But is there a plan B, if you like, if you don't get that consent?
Yes. So this is already plan C or D, something. So the amount of water is not incredibly huge compared to crop irrigation or something like that, but it's still major. We've estimated, or we've been provided 8,000 cubics per year.
Yep. Which
some ecologists we've been working with from like Wildlands and companies like that are saying you've overdone it by an order of magnitude almost. You've been very conservative. You've been very conservative in your water for that number of trees in that location. But that's the number that we went on based on rules of thumb that we were given, 10 litres per year, 10 litres per water per tree. And then 24 to 26 waters per year per season. If we don't get that water the way that we've contracted to, we would need to look at purchasing the water and trucking it on site, or looking at other consent mechanisms. But we appreciate that this is an over allocated resource. We've had other contracts and agreements in place, but they've been kind of they've fallen through for unfortunate reasons that people.
So just going to the trucking option, would that be trucking water tankers coming in and filling up a tank?
Yes. Right, which would be the worst case, I believe. But we've got the mitigation vegetation is a condition of our consent, so we have to do it.
Yeah.
So that's on us to solve that problem one way or the other. We've solved it a couple of times and had it not work.
So do you'd agree that the water situation, whether it's through the consent that you'll be seeking, or whether it's trucking it in, is necessary prior to any planting taking place?
We wouldn't plant without them being able to start it. Absolutely, because they're going to be a condition of our consent. They're part of our application. The visual mitigation is we started with it, and what we believe is how we build all of our projects have it. Not every solar farm does it, but we believe it's something you should always do.
Okay.
No, I have most of my films to Bob.
Okay, thank you.
Thank you.
Thank you. With your leave, would like to call Mr. Coker to present the landscape evidence.
Okay. I'm just wondering, when's the bud due?
Would you like to hear from Mr. Budd now in light of your questions to?
Yeah.
I would prefer that if that's okay.
Yeah.
Okay, yeah.
Hopefully he's on, but we'll try and get him right now.
Yeah, and there's probably a bit of a sequence here in terms of the way questions will go.
No, I'm okay. No, I'm okay.
Yep. Sorry, we should have indicated that earlier.
No, just I want to understand your action.
Yeah, that's funny. Because he's increasing him around the trees. There you go. Mr. Bubb, can
Hello?
you hear us? You can hear us?
Yes, I can hear you.
Okay, great. Thank you. So look, we've read your rebuttal evidence.
Yeah.
We're happy if you want to summarize things, or otherwise we can just go straight to questions.
Yeah, in terms of summary, I guess the main point is that there is the ability, well, there's actually an agreement to transfer some groundwater allocation to this property, and that in our experience, we don't foresee too many problems with such a transfer. So in my opinion, there is or can be water made available for irrigation of the shelter. That's pretty much the main points, really, I think, of the rebuttal.
Okay. We've got a few questions for you, so I'll let Commissioner Bray start, and then I've got a few as well.
Yeah, I just wondered if you could elaborate, please, on how you propose to irrigate the planting. I know you say at 16 it's a trickle irrigation, but can you just run me through the core concept of the design, how it would work?
Yeah, I mean, I haven't looked into the design. We're not involved with that part of it, but it would be, drilling a bore, a deep bore, as I've said. In my view, it needs to be over 50 meters deep. Water will be pumped from there, possibly into some tanks for storage, but that'll be need to be confirmed when the system's designed, and then pumped through pipes for trickle irrigation is my understanding of the preferred method. It could be with these sorts of plantings. It can either be trickle or sort of micro irrigation, if you like, with small emitters at the base of the trees, but trickle will probably be the best way to go. And so the trickle irrigation is just they're pipes with emitters that are built into the pipes that allow water to be discharged at a very slow rate. And the benefit of those is that they discharge water directly into the soil, and so you don't have losses between the irrigator and getting to where the rooting zone for the plants are. So it's a very efficient method of irrigation.
Okay, have you seen the site plans and in particular the landscape plans for the proposal?
No, I haven't.
You haven't. Okay.
But I'm just basing mine on typical plantings for, yeah.
Okay, I'm just conscious. It seems it's a very long and narrow site.
Yep.
I haven't got the distance in front of me, but it's some kilometres long.
Yes.
And there's several rows of planting.
Yep.
So I just want to make sure that system is possible. That would just affect the size of the pipes or something like that you would need to run in order to get from the pump through.
Absolutely. It because of the length of the property, my expectation would be that you'd pump water from the bore to holding tanks, I would have thought, so that you could split the system, so you could pump from each holding tank to emitters rather than having such a long run. Do you see what I mean? So if you put, for example, 3 holding tanks in, then each one you'd split into 3 zones then, or 4 or 5, whatever the design's going to be. But that would be a way of keeping the length of pipe to a reasonable scale where the emitters are still going to work properly. But you're still using the same amount of water. You're just splitting it between different zones.
Yeah.
And by putting it in tanks, you can store it, closer to where the water is actually going to be needed.
Okay. And
Again, sorry.
no, you carry on.
I was saying again, we at this stage we can get involved with the design of the irrigation if asked to, but we haven't been asked to do that. So
No.
I'm talking aloud here in sort of how I would probably look at it, but it's not something we've done any sort of detailed design on.
Okay. Okay, on that basis, well, maybe just one question then, just based on your experience, would laying out irrigation on this site, would you consider that's a reasonably small, easy job, or more towards a large and complex project?
In terms of irrigation projects, I'd say it's very easy and straightforward. I mean, you're talking about one well, one pump from the well. Yes, that then may be split as you pump the water up from the well. You might discharge to 3, 4, 5, whatever, a number of tanks. But once the water gets to those tanks, and again, this is just a theoretical design off the top of my head here. Then you'd have a small pump associated with each of those tanks, and that could supply the zone of trickle irrigation that's serving. So it's very simple, straightforward design. The importance of it is it will be important to make sure that the design is correct. It's not something that we would recommend is just thought of as a standard design, because the lengths will be quite long, and it just needs to be they'll need to make sure that the specification of those pipes and the emitters is correct for this particular site. So it's pretty straightforward, but with a caveat that it needs to be done properly. Absolutely.
Okay.
Mr. Barber, I've just got a few questions about the water take and the consenting.
Yeah.
So firstly, is the take from an existing consented take, which is actually operational?
Yes.
Okay.
It's an active consent, yes.
Yep. So the act of obtaining the water take is as an ECAN matter in terms of obtaining that consent, correct?
Yes.
So what's required from your point of view in terms of that consenting from ECAN?
Okay, so to get the transfer completed, you mean?
Correct.
Yeah.
Yes.
Yeah. So the process will have to be that the bore on this property is drilled and tested. So the drillers will do a step test as a matter of course. That step test is analysed to get one of the aquifer parameters. And then armed with that, I would be expecting that would be enough to draw up the transfer application and put it into ECAN. So it's really drilling the bore is the main thing to do. Sometimes a step test isn't sufficient. It doesn't give you enough information about the aquifer, and sometimes a constant rate aquifer test might be required, which is where you pump the bore and monitor 3 or 4 bores in the area to see what effect it might have. I'm thinking it's very unlikely that sort of test will be required in this instance. The main reason for that is just the size of this take is actually relatively very, very small. And so I'm not expecting that the drawdown effects of the take will be very high at all. So I'm not expecting the detailed testing to be required.
Does the bore require a separate consent?
No, the drilling of the bore itself is a permitted activity under the Land and Water Plan, the regional plan, as long as the driller that is used is a certified driller under the ECAN certification.
Okay. Have you looked at the existing consent?
The one that's being used to transfer?
Correct.
You mean? Yes.
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 So are there any restrictions that might frustrate the consent transfer?
No.
And it's proposed to be, is it proposed to be a temporary or permanent transfer in terms of Rule 12.2?
Permanent.
Permanent?
Yeah.
And am I right in understanding that a resource consent application to transfer under that rule is non-notified and not required, and affected party approvals are not required?
I'm highly expectant that that will be the case. You can't guarantee that until the bore is drilled and we've done the well interference effects. But
Would that mean that, does that mean that you may not meet one of the criteria under Rule 12.2? Is that what you're saying?
it's possible, but highly unlikely, that a neighbouring bore could be shown to be affected, or not affected, but affected to a larger degree than the Land and Water Plan allows, and therefore, you know, in these sorts of situations, sometimes you need the written approval of a neighbouring bore owner. Given the size of this take, I think the chances of that in this instance is very unlikely. So if I go back to I mentioned a constant rate aquifer test a moment ago. The process would be that the bore is drilled, a step test is carried out. If the effects of that, we use the results of that to run the well interference assessment. If that showed that a neighbouring bore or some neighbouring bores were potentially affected, the next normal course of action is to go and seek written approval from those parties. And if those aren't forthcoming, that's when you would tend to do a constant rate aquifer test. Given the size of this take, if a constant rate aquifer test was required, I'd be, you know, extremely confident that the effects would be shown to not be all that great on neighbours, and that therefore you would be complying with all the conditions of the rule.
Okay, so in that circumstance that you needed to go to the neighbour, that means that you default to a discretionary activity rather than being a restricted discretionary. Is that correct?
Correct. Yes. Yeah.
Okay, so if you're able to meet all the requirements set under Rule 12, right through A to D, and including the sub clauses under D,
yeah,
then it states here that a resource consent application for transfer under this rule shall not be notified or served on any affected persons.
Yes.
Okay, so it's only if you're not meeting one of those criteria, which may be an impact on interference effects between bores, which I think relates to policy 4.3.
Yeah.
You would then default to a discretionary activity.
That's right.
If consent were to be granted, would it be prudent to ensure that the take was in place prior to any planting taking place?
I would have, depends on timing, I guess. My gut reaction is to say yes, that would be prudent, but then I guess it depends on the time of planting. But look, yes, it would be prudent because I think it's extremely unlikely, but if there was some problem with the transfer, you know, then you wouldn't probably want to go ahead with the plantings, to be fair. So I think it is fair to say, yes, it would make sense to get the transfer, get the consent in place before you did the plantings.
Look, I'm going to ask Mr. Bramley around the irrigation system. My question really was for you, was the water take itself. I'll ask him around the need for the irrigation system prior to planting, but it was really about the water take. So you'd say that you need the water take prior to planting in order for that irrigation to occur.
Well, you need the consent in place for any irrigation beyond what you can do as a permitted activity, which isn't very much. So, and I think that if you go into the expense of the planting, just tactically, it would make sense to have the consent in place to make sure that you knew that there weren't any hiccups with the consent. Very unlikely there will be, but if there were, for whatever reason, you'd want to make sure that consent was in your hand, I'd have thought, before you spent the money on your plantings.
What's your experience in terms of obtaining these consents time-wise from the time that you commit to drilling the bore to the time that you obtain a consent?
We deal with a high number of these sorts of transfers, so we've got good experience with that. From once the bore's in the ground, typically, I guess, after drilling, an application is lodged, I'd say, within a couple of months of the bore going in the ground. It can be a bit quicker than that. It can be slower, but depends on workloads, really. And then once it's with ECAN, you know, they've got the statutory time frames to deal with it, which is 20 working days. So, you know, sometimes they might have questions in terms of requesting further information within an application, which can extend the time frames. But, you know, typically I'd say from drilling the bore, 3 or 4 months.
And do ECAN typically impose a suite of conditions on this?
There's a suite of conditions, but they're all standard conditions.
And
yeah, there's nothing. Sorry.
What are the standard conditions that you get?
Well, outlining the maximum rate and volumes, which is, you know, what we'd be applying for, what the water can be used for, which would be irrigation in this case. There's a condition there about relating to water metering, for example.
Okay, that's what I was looking for.
Sorry?
That's what I was looking for. So there's a metering requirement, and is there a requirement to report that?
The size of this take, and I don't know, we'd have to talk to the irrigation designers, but the rate of take, I suspect, will be less than 5 litres a second. And so it actually comes under, or below, rather than under, the requirements for a water meter under the national water meter regulations. So typically on a consent, if it's less than 5 litres a second, there's a condition that says that a water meter will be installed within 6 months of ECAN requesting that in writing. So that would be the typical water metering condition on a consent of this size.
Right, okay. Okay, I think that's all the questions I've got on this.
I just had one, just a small clarification, actually. It's not a biggie. Just paragraph 15, you say it's a transfer of a seasonal volume. Can you just explain what you mean by seasonal?
Yeah, it's the annual volume.
Annual.
So consents. Yeah, I'm quite specific about saying seasonal rather than annual, because often when you say annual, people think it's a calendar year, but it's not. It's the volume is from the 1st of July to the 30th of June, and that's the volume that's transferred. So it's not the litres per second that's transferred. It is the seasonal volume.
Total. Yeah.
Yeah.
Thank you.
Okay.
Great, thank you very much, Mr.
Thank you.
Buck.
No problems. Okay, thank you.
Okay.
We have Mr. Simon Cooper on landscape
Okay.
next.
Welcome. Okay. Obviously, we've read your evidence and the various appendices to go with that, and then a supplementary statement as well. So we're happy for you to sort of, if you want to outline, summarise your evidence, and then we'll just go to questions.
Okay, so not read the summary? Just
Yeah, if you've got a summary, I'm happy, yeah, we're happy for you to read it. Yep.
Ko Salmon Cocker Aho. My qualifications are as stated in my evidence in chief. To describe the site in its context, the site is situated within the plains landscape type. Plains landscape type is described as being generally categorized by broad and very low angle coalescing outwash fans and associated low terraces of the major rivers extending south to include the plains on which Amberley and Rangiora are situated. These landforms are evident in the landscape around Waipara, where to the south of Waipara Township, Weka Creek converges with the Waipara River. These two land watercourses have cut into the alluvial deposits to form a series of terraces, separated by terrace riser slopes. Some subtle, but others being more substantial, being approximately 4 to 5 meters in height. The sequence of terrace and terrace rises lend a structure and legibility to the site in its context when viewed from the opposite side of Weka Creek to the north. These landforms are particularly evident in conditions of low sun, when shadows accentuate the rises. The landscape is lent a rectilinear structure by shelter belts, these being widely spaced. Given the flatness of the landscape and depending on the location of the viewer relative to these elements, views tend to be contained or interrupted by these vegetative features. To the north and northwest, contour continues to rise, with the downlands and Weka Pass contain this edge of the plain. Within the plains landscape with large skies and distant views across a flat landscape, attention tends to be drawn to this elevated terrain, such as the Deans to the southwest or Mount Cass to the southeast. The landscape in its landscape context is already modified from its natural state, characterized by productive agriculture, transmission infrastructure, and lifestyle properties. The area of panel coverage has been reduced from 64 hectares, which is 26% of the total area, to 59.66, 84.6% of the total site area. The proposed solar farm will utilize a flat axis tracking system and are now in a 1P by 28 format. When flat, the panels are 2.38 by 32.5, which is with a central height of 1.9 meters. When at full tilt of 55 degrees, the maximum height of the panels will be 2.77 meters. The key elements of the project are as follows. The project will require minimal vegetation removal and will retain some of the established shelter belts on the boundary of the site. The project includes ecological enhancement on the terrace rises. The project will retain agricultural production and land uses between the solar panel rows. The project will require minimal earthworks and recontouring. Agricultural production will be maintained with grazing afforded beneath the panels. Any effects of the proposal are reversible so that when the solar farm is decommissioned, the site will be reinstated into its current condition. Solar panels will be set back by a minimum of 10 meters along State Highway 7 frontage, separated from the highway by an exotic shelter belt screen, which will be maintained to a height of 5 meters. I note that these roadside shelter belt plantings can be established as a permitted activity. Just a break from my written summary there. There is a condition which requires a shade screen to be erected along that State Highway 7 boundary until the plantings reach 5 meters in height. Now, my recommendation would be that that shelter, rather than have a shade structure sitting there for 5, 6, 7 years, that the shade structure will be affixed to the security fence and the planting will be in front of it. So relatively swiftly, that the planting would screen that shade structure. I am advised, I think of it. one more thing. The proposed landscape mitigation planting comprises boundary screen planting, internal screen planting along terrace rises, and native revegetation of the terrace rises. And these will, over time, screen, soften, and fragment views of the solar arrays. I'm advised that after year one of commissioning of the solar farm, water for irrigation will be available for use on the terrace slope rises during dry spells. It is intended that the revegetation planting on the terraced slopes be staged, with the first stage being undertaken in year 2 following commissioning. At this time, irrigation for the terrace riser plantings will be available to assist initial establishment. I'm of the opinion that a landscape and vegetation management plan should be required as a condition of consent. The details for site preparation, plant supply, implementation, and ongoing management, including monitoring of these plantings, should be required. The principal visual audience includes users of State Highway 7 and residential viewers on the western side of Glenmark Drive, and the western side of Mackenzie's Road, where residencies occupy a terrace riser and have the potential to obtain views to the west, northwest, or southwest across the braided river to the site. My assessment of the visual effects has been modified since my initial report, informed by site visits, representative viewpoints, and by submissions. Whilst this has not changed my opinion on the extent of the visual catchment or the potentially affected individuals to any great extent, it has enabled a more detailed understanding of the relationship between the site and the surrounding visual catchment. This has included the Waipara Pass Railway, and visual simulations from a representative vantage point is attached to my evidence. It is my opinion that the proposed solar farm will have moderate adverse effects on landscape character over the short term, 0 to 5 years, diminishing to low to moderate thereafter. I consider that the visual effects experienced by the occupants of 2 dwellings located on Mackenzie's Road to the east of the site will be high, and moderate to high for the occupants of 1 dwelling, diminishing to low for all of those as the mitigation planting becomes established. And I note that the 2 properties where I've assessed a high rating, only one of those has made a submission, the other one I believe hasn't. Visual effects experienced by the occupants of 1 dwelling located on Glenmark Drive to the east of the site will be moderate, diminishing to low as the mitigation planting becomes established. The visual effects experienced by users of State Highway 7 will be moderate initially, diminishing to very low as the mitigation planting becomes established. The visual effects experienced by passengers on the Waipara Pass Railway will be moderate initially, diminishing to very low to moderate as the mitigation planting becomes established. So,
Thank you.
Thank you.
I'll let Mr. Bray start on this. I think you've got a few questions for you.
I do have a number of questions for you, so I'm sorry, get comfortable. Most of my questions are really about trying to help me wade through a huge amount of material and really understand this, and to also try and understand where you've come from compared to Miss Annan, because you are quite different and where you've got to. So I really need to flesh that out and get to the bottom of it. So none of these are really digging personally. They're just really just trying to help me understand things, but we're going to get into some stuff. I just wanted to start, your history and involvement, I think is pretty clear in your paragraph sort of 7. I just want to know, have you visited a constructor or operational solar farm? You've been on a site? You have?
Yes.
You have, great. Okay, now I want to go through your documentation because there's a reasonable amount of it, and I just want to get some clarity that you prepared an assessment in 2024. That was your
2000.
Your first one was included with the application, was dated 2024. You then provided a second revised assessment in 2025.
Thought the first one was in 2023, but
Oh, I think it's, okay, could well be. It's dated, I think the front cover is dated
yeah, there were a number of iterations.
2024. But there was one initially, and then there was an RFI from the council, and then you provided a revised assessment, which was essentially your second one, and that's the one, your key one. You then provided a response to our minute 6, and then you provided your evidence and then your rebuttal. And I just want to go through some of your methodology, particularly, Miss Annan has been quite critical of some of this. So I want to just explore that with you. In your revised assessment in 2025 and in your evidence, you don't include any methodology. I'm assuming that we go back to your very original assessment, and that had an appendix to it, Appendix 2, which contained your methodology. That's correct?
That's correct.
So that methodology hasn't changed through the process since that assessment?
No.
No, okay. At paragraph 9 of your evidence, so you say there that it's been prepared with reference to the concepts and principles of Te Tangata Manu, this document here. I just wanted you to explain what you mean by the term with reference to. I'm aware that I think page 236 sort of suggests that's the terminology used, but I just wanted to get your opinion on what do you mean by with reference to?
It's not distancing myself from the document. I mean, I believe that I have implemented used a methodology which is consistent with Te Tangata Manu.
Okay, but in your Appendix 2, which is your original methodology, you make quite strong indication that your methodology was undertaken with reference to the quality planning landscape guidelines, and also signposts quite strongly to the UK guidelines, the GLVIA 3, as it's known. So just trying again, and Ms. Annan is sort of trying to find her way through this as well, where she says that there are core differences between GLVA and Te Tangata Manu, which I'm sure you've read what she said there. Can you just therefore explain what you think do you see a difference between the UK guidance and the New Zealand guidance, and how you might consider your methodology might be different?
Well, I guess my methodology over the years, I mean, my approach has changed over the years as Te Tangata Manu was brought in and gained an understanding of that. So there's been a gradual shift in my understanding of how the assessment should be undertaken. So I guess my answer to the first question, I'd saying that there's no difference from my first assessment to the way I see it now. I mean, there's been a kind of a gradual change, I suppose. I believe that the way I've approached my assessment, or the way I've approached my evidence, which is the latest thing, is entirely consistent with Te Tangata Manu. Okay.
I mean, I think, to be fair to you, I mean, Te Tangata Manu came out late 2022. Your first assessment was 2023. We were all getting used to it, myself included. And so my question really is as that change has happened, has the way that you've looked at the project, as you've become more familiar with that guidance, as you've gone into the 2025 and then into your 2026 evidence, has your process of considering the application changed?
I mean, I believe it has, and I think that's probably evident in looking at the way I described the landscape and assessed the landscape in my original report, and the way I've presented it in my evidence. I think that's kind of implicit in that change.
Okay, so with that change and that refocus, I guess, into perhaps a different way of thinking in a much stronger New Zealand context, your conclusions though have not changed.
They have. I think my assessment of the landscape effects originally was low to moderate. That's different now.
Okay,
So my conclusions have changed, and the same with some of the visual effects as well. I mean, I accept I probably should have updated with the iterations of my report. I should have updated my scale of effects, because in that first report I don't have the same scale of effects as presented in Te Tangata Manu. That's the scale of effects that I use now in my assessments, Tangata Manu one.
yeah.
So,
Well, that's great, because it actually leads directly to my next question. Is, yeah, in your appendix 2 from your first assessment, it's not referenced, but you're saying now that in your evidence, you're using the scale as it's written in this document. I think it's in 2 places. Section 6.21 and section 6.39 is where it sets out the 7-point scale and how that relates to effects in RMA context as well. So that's the scale that you're now have adopted for your evidence. This is correct. Right. Right, this one, I think I hinted that was coming. If we go back to your original assessment that was lodged with the application, at section 4.2 of that original assessment, if you got it or can get it up, you may not need it.
Yep.
So at that 4.2, you talk about statutory matters. There's 2 bullet points there. The second policy you've noticed is in regard to vegetation clearance. And then in your photograph 3, at the end of that document, you have a photograph across the plains that includes the image of the Matagari that has now been cleared. So that photograph was taken prior to the clearance of the Matagari.
yeah.
But then under the bullet points, you state that let me just,
Are the bullet points back in 4.2?
yeah, 4.2, that you reached the conclusion in regard to that policy that it would not be infringed by the removal of any vegetation. So I just wonder if can you take me through your assessment of the native vegetation on the site and how you got to that conclusion that nothing would be cleared?
I understood, well, I visited the site in, you see, it was not ideal weather conditions. I walked over the site. It was my understanding from that native vegetation wouldn't be removed. Yes, I can't go beyond that. I understood that no native vegetation was going to be removed.
But it's in your site plans that are also attached to the same report that there are solar panels right across the top of that vegetation that you've taken a photograph of.
I mean, as you see from that photograph, I mean, I guess I wasn't aware of the entirety of the area of the Matagari that was there. There's in that photograph, just the odd plant here and there, but
so what I'm interested in is so your assessment of the Matagari at that time was that it was not of a large area. Is that what you're telling me?
That's exactly right. As you see from that photograph, you don't get the impression that there's an extensive area of the Matagari there.
And are you used to dealing with Matagari? Have you come across Matagari before and its growing habit?
I've come across it. I wouldn't say I deal with it on a frequent basis.
So I'm interested, in terms of the way you would professionally undertake an assessment, if you'd come across it in a arrangement like that that's shown in photograph 3, and my understanding is from the aerial photos that the large patch to the left extended a lot further. Would it have not been prudent to seek more advice or input
Well, I
into?
was relying on ecological advice.
But where there was no ecological advice at that time, we didn't have ecological advice until a Section 92 request a year later.
Possibly it would have been advisable to seek further advice.
Okay, so considering that you were not able to fully identify that area at that time, I just want to understand, is there anything else in your assessment that you have relooked at or are concerned about that you might have missed?
No.
No, okay. All right. Let's turn to some planting. I want to take you through the landscape mitigation plan. And obviously you'll know that, this is one of the big discussion points from submitters. And I want to start with and just look at the screen planting. I'm not talking about the native vegetation planting, so just the screen planting. So there's two elements. There's the boundary planting and then there's internal screen planting. That's correct, yeah. And that you are really relying on both of those for the mitigation of visual effects.
Yes.
Yeah. And what we have for that is cypress and thuya, that are the two species. And what I note from your landscape management plan is that they're in two different planting grades. I think there's a small PB2, small grade, and then there's a larger grade.
There's the cypress PB2 and the thuya 2.5 litres. Yeah.
But there's also an option to have a larger grade. Is that right? Am I reading that correctly? Let me bring it up and I'll have a wee look. Sorry, just wait for it to load here. So I just want to be really clear about what's being proposed where, because I think the plans are quite small. So I just want to be really clear what grades are being proposed around the boundary and what grades are being proposed to be planted internally as the screen planting. Do you follow where I'm at?
Yes, I do see in the schedule where you're referring to. Yeah, I do have two grades in there. The intention was just to plant the smaller grade.
The smaller grade. Yeah. So we should strike out the PB8 from those. So it would only be the smaller grade to go in. Okay. And you have the height then in those areas is the height at 5 years?
Yep.
I think you say 4 to 5 meters, or 3 to 4 meters for both after 5 years.
That's correct.
Yeah. Okay. And then they're going to be maintained at a 5 meter height at that point, which I think you cover your paragraph 82. And so how long do you think, so you think 3 to 4 meters after 5 years, how long to get to the 5 meter in height that they'll be maintained at?
A year or two after that.
Those 6 to 7 years, 6 years, okay. And that is dependent on irrigation, correct? So in order for those smaller species, the Cupressus and the Tuya, to survive and grow to that height, 3 to 4 meters in 5 years, or 5 years and 5 meters in 6 years, you need the irrigation for that to work. Okay. So in terms of that irrigation, you would have heard that conversation we were just having. I'm a little bit lost because there are different references to where the irrigation is proposed. And I heard you say in your verbal submission that the irrigation is for the revegetation planting. Does that mean that there's no irrigation for the boundary planting, or that the irrigation is for all planting in the solar farm? Is that correct?
The irrigation is primarily for the boundary plantings.
Primarily for the boundary planting.
Mitigation planting. I'm advised that there is sufficient water for the boundary planting.
Boundary planting.
Yeah, for those, yeah, to get them established. After year 1, there will be an excess of water which will be available for other plantings.
Right.
Revegetation plantings. My view is that it will be preferable if those the riser plantings, the revegetation, to have irrigation when it's in the early years, when it's first establishing, just to ensure better success.
So that irrigation needs to be in at time of planting, or very soon afterwards.
Which is why I'm suggesting that riser planting, the revegetation planting, is implemented at year 2 onwards, so that there is irrigation available.
Yeah, so the boundary planting comes first. We put the boundary planting in, follow it pretty quickly with the irrigation. We're at the same time. Yeah. And then a year later, you then get into the revegetation planting in the centre. Okay. Okay, and then Ms. Alcamo, at paragraph 141 of her evidence, she says that the irrigation is only going to be needed for 3 years. Would that be your assessment as well?
So irrigation for?
She says a period of 3 years.
For which?
For all irrigation.
3 years would certainly assist the initial establishment. I think it might be preferable to have it for longer than that.
So preferable to have it for longer than 3 years. Yeah. I mean, we heard a short while ago, it seems that the transfer of the consent will be for 35 years, but I just want to cover that off. Can we just have a look at some of the cross sections for your planting in your management plan? We could start with the boundary planting. So my understanding of those two species is that they grow out as well as up.
Mm-hmm.
And so there will be a requirement to trim them. Yeah. This may be a question for Ms. Alcamal, but whether there's a consent required or I think they call it a corridor access requirement from NZTA to maintain the planting along the road, the state highway. Do you know anything about that? No. Okay, I'll come back to that. Yeah. I'm also interested with the security fence there. Were you imagining the planting would grow through the security fence and then you would maintain on the other side of the security fence?
Well, that's planted corridor is 4 meters wide, so it's got
room.
Yeah, you've got a staggered row planted in the middle, so there's room on either side. I anticipated that certainly early on, the management would be undertaken from within that corridor.
Yeah. And then afterwards.
But afterwards
from outside. Okay. And then if we look at your cross section for the internal screen planting, I think it's detail K. Are you envisaging that you wouldn't maintain or trim the vegetation on the top, on the side that faces the slope?
I think it's less critical. You certainly wouldn't want it going too far out over the slope because it would start suppressing
the planting underneath.
the planting. Yeah.
Correct.
So, but I think if you kept on top of it, rather than not letting it get to.
But how? Just a practicality. How would you do that?
By hand, pretty much.
By hand. Okay.
And again, I think it's more a case of timely maintenance.
Okay. Let's turn to the revegetation planting. And I wanted to in particular turn to the report that you attached to your evidence by Mr. Rees. And I think you made reference to that at your paragraph 67, where you talked about dryland communities, and that's the basis for your revegetation planting. I was particularly interested in the very last paragraph of Mr. Rees's report, where he stated, "This is one of the hardest restoration sites I've ever seen. Difficult issues to think through and challenges with irrigation."
Well, I think that was your last few words there with the key. He came from the premise that there wasn't going to be any irrigation.
I think he was suggesting that if you irrigated, it actually would create issues.
No, that wasn't my understanding from my contact with him. I think he was concerned that there wasn't going to be irrigation.
You got something on that?
Yeah, I've got, it says that while irrigation is an option, it runs the risk of creating communities which really are not typical of the site.
Okay. That's a matter of maintenance, management of the way it's managed. The key is to get those plants established initially, and I think that was one of his comments. He was saying it's difficult to establish things on this side.
Right.
I think that was the thrust of his comment when he said it was one of the most challenging sites.
I think his concern was that if you start irrigating, that there'll be non-target species will start to grow there, but as a result of irrigation.
Well, if we're using irrigation just in those first few years to get it established, it's just a management matter.
Okay.
So what you're saying is going to require maintenance?
Oh, most certainly, yes.
And so that maintenance, because there's nothing in your draft management plan about maintenance requirements.
No, I was suggesting that came as a condition of consent.
Condition. So that I think is contained in the proposed management plan. What's up? The name of the conditions. Scott.
It's condition 28.
Yeah. So there's been a few changes to that condition. I just.
Okay.
Yeah, wanted to make sure that, in your opinion, does that condition cover all of the aspects that we've just talked about in terms of getting those trees, the plants established, and then continuing to maintain them so that they grow to provide the mitigation that you're proposing?
No, I think the conditions still need some work. There's no reference to staging in that condition, for example.
Right.
If you can pull up the conditions. And I think that that condition needs crafting some more. I mean, as we just talked about, with the specific requirements for manage the early year irrigation and also the early year weed control to ensure, as John Priest identified, that you're not going to get unwanted species coming in there. That you're favouring the community that you're trying to.
Yes. And in that condition, I don't think there is anything, not just about the staging, but about any time that the planting will actually start, other than condition 26. It's the revised condition, was 23. Landscape mitigation shall be planting at the first available planting season after installation of fencing.
That's what I mean by the staging.
Yeah. You may not know the answer to this, but I couldn't see, and I just may have missed it with the amount of material. There is no requirement for the fencing to go in. And there's no date at which the fencing might go in. Okay, we'll have to come back to that.
Can I just jump in on, there's a question around the same conditions here. You indicated in your evidence that the precise location and extent of alternative species mixes is yet to be finalised in consultation with neighbours. Would you expect that to form part of the conditions as well? Because again, there's no reference to, other than 28A, which talks about the details and numbers of trees and shrubs, there's no reference to the consultation with neighbours. And then
there would need to be something which provided for that.
20 to 1.
Do a break.
Yeah, look.
Yeah.
Might take a break. Yeah, we're 20 to 1. We're past 20 past. 20 past. 20 past. Yeah, 20 past 1. Can we break till 20 past 1? Okay. Okay, we're ready to go.
Right, Mr. Coco. Just want to really briefly touch on windbreak, which I think you mentioned earlier as well. Mr. Andrews, at his evidence, I think it's paragraph 38, he introduces the proposal to now install windbreak cloth along state over 27. I think he's refers to it in an image attached to his evidence. It's just attached to the security fence. And it's basically the same as your drawing in the landscape mitigation plans, but it's got the windbreak added. So it's just is the same. Mr. Andrews says that shade cloth 50% black, 2 metres high, preferred by the landscape architect. And I'm assuming, am I correct? Does he mean you when he says it was recommended by the landscape architect?
I can't recall. I mean, recommended in terms of the colour or recommended in terms of the.
Yeah, correct.
Yeah, I would recommend that it was dark colour.
You said dark colour. And the 50%, you don't recall why you chose 50% versus
No,
shade cloth 50% black, it says. You don't recall why that was chosen, why that particular.
I need to refresh my memory, but I can't.
Just want to pull that mic a bit close to you. That'd be good.
Okay. Well, let's turn to the visualizations, which I want to work through with you. So my understanding is we essentially have 3 sets of visualizations. There is, I'm going to call it set 1. I don't think they've got numbers, but I'll call it set 1, which is from public locations. So they're viewpoints 1 to 9. And I think in that set is also viewpoint 247 from 247 Mackenzie's Road. Then there's set 2, but again, hasn't got a number, but I'll give it that, which are the visualizations for private residents. So that's viewpoint 55, 97, 251 and 247 is repeated in there. And then we have set 3, which is the Waipara Railway.
Yeah, they were prepared at different stages, different times. So the set 1, as you've called them, was prepared initially.
Yeah.
Set 2 was when we were able to get access to
the private residents,
private properties, and then the set 3 was
the one I requested.
Yeah.
And you also, we know that they've been created by a third party, Virtual View, and their methodology is provided separately.
Yeah, that's correct.
Which is fine. Okay. So I want to just understand when these visualizations were prepared, and I need to go through with you and understand what we can rely on in those visualizations in terms of them representing the proposal. So that set 1 that we just talked about, which was the public viewpoints, you said was done initially. So that was prior to the 2025 work. And so that means they are prior to all of the changes that Mr. Andrews talked us through earlier.
There were a number of iterations of the visual simulations. Some of them were redone based on the change of the type of panel. And at that time, the angle of the panel was also remodeled.
But that's not the public visualizations, have they? Because we haven't been provided a new set of visualizations from the public locations.
That's right, the public location.
With a revised proposal.
Might have to go back and check this and then provide that.
Well, we're going to need to bring them up. So I'm going to go through them because it's really important we understand what the visualizations are showing us.
Yeah, absolutely. The ones from the private locations were definitely remodeled.
Okay.
Based on the new panel type, height, and also the angle as well.
Right. So if we go, let's for example, let's pull up the ones from public viewpoints, which were the ones attached to the original application, because that's the only set we have of those. I think what I have is those are dated They were prepared 25th of September 2023. And there's no changes. No changes have been made to those, is my understanding.
Yeah, that's correct.
That's correct. Okay. So if we were to look, for example, at viewpoint 4, and Mr. Andrews touched on this before, the vineyard that's shown in that visualisation is no longer part of the application.
Yeah, that's correct. Yes.
And we don't have a visualisation showing the visibility of solar panels from that location without the vineyard.
No.
No. But it's likely that we would see, in fact, we can still see solar panels from that location. You can see them in.
I'm waiting for that.
Oh, you waited for the code?
To download. So, which,
We got a printed set. Maybe we could share with Mr. Coker. Has anybody got a printed set? I've got them here. See those ones. All of them. Yeah, that's all right.
this one here. Viewpoint 4.
Yeah, so viewpoint 4, there's a visualization there, which it's probably easier if you go to the zoomed in image, which is the central one, it's just 2 pages later. You got that? So that vineyard is no longer in the application, so that we have to disregard that out of that visualization.
Yep.
And so that means that there would be a greater view of solar panels from that location of that than is depicted in the visualization.
No, I don't think solar panels are in that southern section there.
Yes, but aren't they screened by the vineyard in the foreground? You can see them in the background, but then they disappear behind the vines.
Oh, sorry. Well, where the grapes are in the foreground.
Yeah.
There's no panels there.
But if you look at the panels at the back,
Yep.
you can just see a little element of them.
Yep.
And then you can see that the vineyard is coming down across the front of those solar panels. So that would indicate to me that from this location, the vineyard is actually screening the panels.
Yes, but then you've got the shade cloth on that. Shade cloth on the planting on that.
So has this now changed that we now have boundary planting along that boundary? Is that what we should be considering?
Not along the road boundary, which is in the foreground. There's planting along the site boundary, which is set further back.
Okay. And we don't know, or you don't know whether that boundary planting is shown in this visual or not. I can't see it. I can see some boundary planting coming up the hill to the left-hand side, going just in front of that pylon, but I can't see it behind the vineyard, so I don't know whether it's there or not.
Yeah, no,
We don't know.
without going back and looking
No,
at the
okay.
plans for that date, I couldn't tell you.
All right. And then we'd have a similar situation on visualization 5. The vineyard wouldn't be seen in the ground. And we can't tell whether the boundary planting along there is included in the visual or not.
Just to reiterate that southern area, which we're seeing as the foreground of
Yeah.
right here, that's not replaced by the left-hand end, isn't replaced by panels.
No.
But I mean, I wouldn't imagine it's screening anything because I mean the grape plant is quite low, so you would see.
Yes, but what we don't know is because the visualization had the vineyard in it, was there boundary planting between the vineyard and the panels? Because I can't see the exotic boundary planting in those visuals, so I don't know whether it's there or not there in the visuals. That's why I'm trying to understand.
I mean, again, I'm going to have to go back to the plans at that time to tell you whether there was. I mean, it's
Okay.
Going back and comparing what was used in the preparation of those simulations at that time.
Right. Okay. I think I've got your plans. Well, I do have your plans original, so I'll have a look at that.
But would you like me?
That's all right. I'll have a look. I'll have a look later. But what you're suggesting is if your plans show that there was planting there, then they would have been modelled by virtual view. Okay. But while I've got these ones over, I'm just going to jump forward a little bit to a slightly different thing, but it's while you've got these open, and it's on viewpoint 3.
Yep.
So in the long view there on the viewpoint 3, the full visualization, there's a road sign on the left-hand side.
Mm.
And behind that road sign is some pine trees. Now, my understanding is that those pine trees are to be retained, but will be reduced to a height of 5 metres.
Yes.
So that's not shown in the visual underneath. The visual underneath shows the full clearance and replanting. Have I got that right?
Yeah, right.
Okay. And whilst we've got that visual open, I just want to inquire as to whether, in your opinion, based on growth rates and understanding that we're going to plant that boundary planting, as you confirmed earlier, at PB2 size, which is what, 30 centimetres high out of the ground, maybe a bit more. whether you would get that height and that density of planting within 3 years, as demonstrated on that visualization. I mean, I'll take you back, of course, to our earlier conversation in terms of your schedule indicates that they will reach a height of 3 to 4 metres in 5 years. But this seems to be showing reaching that height and a considerable density in 3 years. Is that an accurate representation of the vegetation?
I think it may be overstating it a little bit.
So what year would you suggest that planting is modelled at?
5 years.
5 years. Okay. And so that would be the same for all of the visuals that are indicated it has vegetation like that at 3 years. So for example, visualization 1, visualization 2 in particular.
I mean, bearing in mind there's going to be a 2 metre high shade fence.
Yes.
That will provide.
Which we can't see in this visual because the planting is too thick. So we haven't really got a way of being able to see from these visualizations what the effects of the solar farm would be from these locations in that first 5 years.
Well, if we assume this is 5 years.
Or even the 3.
No.
No, okay. If we can then turn to your visualizations from the private properties. And perhaps easier viewpoint 55, but maybe we'll start with that one. And I think probably again, if we go to the more zoomed in one, which would be either the second or third image. I know it's the one with the transpower pylons in it. I think it's 55B. Yeah. We don't have in that image the any proposed substation or grid connection point, do we? That would be underneath those transmission lines. Based on what Mr. Andrews said this morning.
Not that I can see in the principles.
And I'm assuming there would be some kind of ground to aerial poles to allow that connection, which again, we can't see. Yeah, okay, so we just need to bear these in mind when we're looking at these visualizations. If we now go through to 251 from the privates, and again, I think if we go to one of the zoomed in ones, I think we can see the boundary planting there, but I just wanted to confirm, do these show the 1P solar allowed or the 2P?
1P.
Because when I look closely at the lines on them, it just appears to me like they're this double stack, but you're confirming these are 1P.
That was my understanding.
Right. Okay. I think I've got that. And in that, if we look at 247A, was the two chairs in the foreground, and then we look to the boundary planting. That boundary planting again, we think is emphasised in terms of its growth.
Well, that's planting in year 5.
Yeah, that's year 5. So is that more realistic
Yeah, I believe so.
for year 5? Okay. And again, given that the native planting on the terraces you have suggested would take place in a staged approach, starting year 2, is that, and then the next one at year 10, and given our conversation about the difficulty of establishing this vegetation, are they accurate representations of the native vegetation?
Well, the staged approach was really came into the mix at a later stage, after these visual simulations were prepared. So that was more recent. That was when I was preparing the evidence. So that planting shown there would be delay it a year.
Okay, so again,
So it's probably showing more than would be there at this.
the planting in those images is also overemphasized. Okay.
Well, I wouldn't say it's overemphasized. I'd just say it's representing a year later than it actually should be.
Okay.
But although, the planting on the terraces, it's less of a question of scale. It's more of a question of texture as the plants develop and spread.
Mm-hmm. Okay. While we're on that visualization as well, just those higher views, I think both 247 and 251 are good areas to include it. I mean, based on your observation of operational solar farms, when you're located, I think in this instance, to the northwest of the proposal, was it northwest? The panels wouldn't appear black, would they? They appear much whiter.
Depends on their angle in relationship to the sun.
Okay. So in this instance, in the middle of the day, the panels would be flat. I think that
Yeah, 130.
the time of the image is 1:30. So the panels would be relatively flat. So when looking from this angle, essentially to the north, when you're looking back at the panels, they would have a much more white appearance to them than black. Would that be a?
Well, I'm relying on them.
Yeah, but I'm asking in your opinion of what you've seen of solar farms.
Sorry, it stopped generating on my screen. In the 251, but you've got planting at year 5, you get that whiter shading across to the right.
Off to the right, yeah.
So I think it really depends on the angle. I think that accurately reflects the situation. Depending on these panels cover a wide span. Part of the farm might have more of a white tinge.
So that white cover will move across the panels during the day as as the panels
Yeah.
twist and the sun moves across the sky.
A few kind of changes as with the position of the sun.
Yeah. Okay. All right, I'm going to come back to the visualizations, but I just wanted to go through the what they were showing us so we can be clear on that. Let's just look to your context and get into some landscape effects. I think from what I read of the joint witness statement is that in terms of describing the context, existing environment, you and Ms. Annan are largely in agreement.
Yeah.
Around that. What I would be keen to explore with you is more about rural character, the rural character of the site, how that might be informed by more perceptual or associational aspects of landscape, which are really covered in the Te Tangi Ata Manu, and then how they might be affected or impacted by the proposal. And I think when we go through this, that perhaps what we should look at is come back to the 7-point scale for each of those, just to help me understand where you're sitting. In terms of the physical changes, I think there's pretty much agreement between you and Ms. Annan on the physical changes that will happen to the landscape. So I think we can probably park there. But let's have a look at perceptual values. So how perceptual aspects of landscape might inform what people consider to be rural character. So I'm thinking about things like sound, smell, dust, and how these change. And I think you mentioned some of those in your reference to the district plan at your paragraph 100, but I wonder if you could elaborate, what other perceptual elements have you considered, perceptual landscape values? Where would you say you largely rely on that?
It's people's perception of the wider environment, so the views to the long views to the backdrop hills,
Yeah,
the midground, and the way that landscape expresses itself at the moment is this very spacious, expansive midground pastoral character. With changes through the seasons and through the day, angle of the position of the sun, particularly in relation to those terraces. The angle of the sun brings those out. You get changes through the seasons. So you get snow or
so how would some of these things, so let's talk about, you just talked about transient effects, how things change. How is the solar farm going to change that perception of transient movement? We've just talked about one thing, which is the light across the panels. So how does that influence your consideration of how that impacts rural character? I mean, that's a change, isn't it? If the light moving across the sky wasn't reflected across the grass, but it is now going to be across the panels, that's change that's perceived by people. Is that not right?
Oh, yeah. I mean, undoubtedly there will be a change in that midground view. I'm not disputing that. I guess what I'm saying is that the change in the way the panels or the farm is perceived, fragmented by the terracing, by the planting, by the existing vegetation. Whilst there is a change in that character, that change is, in my view, an acceptable one, bearing in mind that there would be a change in the landscape character if, for example, those terraces were planted in vines. There would be a change in the texture and patterning of those terraces.
So, yeah, so can you explain that? So there's going to be a change in the patterning of the terraces. What do you mean by that? How will that change?
In relation to,
Well, yeah, I mean, the solar farm going in, you just said it, that the solar farm will change how people perceive the patterning of the terraces. Isn't that what you just said?
I was talking about in relation to planting vines there, in terms of the patterning.
Right.
But how would the solar farm change it? I mean, in my view, that you'd still, the planting that's proposed on the terraces, the revegetation planting, will emphasise the form of those instead of just a quite simple landscape character that exists at the moment, where you have pasture terrace, pastoral grass is on the rises, and then the pasture terrace. The expression of that really comes from the angle of the light. So you read those individual terraces and the individual rises. Now the terraces will have these low panels on them, so there'll be a change in the colour, and there will undoubtedly be a more of a grid-like texture to it, but the expanse of that will be fragmented and softened by the rises, which will be planted with the revegetation will be revegetated, and so with the texture and the hues of that will emphasise the form of the rises. So you'd still have an appreciation of that terrace landform, but it'll just have a different land use associated with it.
I mean, can we look into that in a bit more detail, and perhaps we should use a visualization. If we went to viewpoint 247, which is in that sort of second set. So there's, again, I think if we go to perhaps 247A, there's an existing image there where those terraces appear to be quite evident in the shading of and the texture of the grass. And then in your image, your opinion is that the planting has made those terraces more apparent.
No, my opinion is that the planting emphasises those terraces. It maintains your awareness of their existence, and that will and the prominence of the terraces will change as the panels move. Some at some stages, with the panels are at a relatively steep angle here, so they're hiding more of the terrace riser, and as they lower, then you'll be more aware of the structure of the terraces.
Okay.
Can I just ask you a question then? Can I just take you back to viewpoint 4?
Yep.
So what, in your opinion, does a vineyard do to the terraces? So you talk to us about panels and the revegetation. What happens when you put a vineyard over those terraces?
Well, that was my point earlier about how, with the change in land use, permitted change in the land use, it will affect the perception of how that landscape is working, how that landscape appears, and so that the vineyards will equally. So the vineyards will also diminish your perception of the terraces, particularly they're lower.
So I guess what I'm pointing again to is if it is the same, so the solar farm is above the terrace, below the terrace, regenerated planting in between. That depiction there in viewpoint 4 just shows a vineyard over the terraces, below, on, and above. So does that actually diminish the terraces virtually entirely? If you look at that.
Well, in that view, it certainly softens the contrast, but in the existing situation, you clearly see the flat terrace and then the riser, which is quite subtle in that situation, subtle riser, the terrace, and so you are aware of the form of that terrace. Put vines over the top of it, it smooths it out, so you lose your awareness of it.
Okay. I mean, let's keep that visual open with the vineyard. I think it's quite helpful because I think a key point around this, and it's where there's clear difference between yourself and Miss Annan, is that you don't consider the panels to be industrial in nature, whereas I think she indicates that they are industrial in character, just not in activity. Is that right? Have I got that right?
Yes, because I mean the solar farm, you don't have, it's not got the same activity that you would associate with an industrial activity. It's a utility in my view. It's a utility.
So tell me what's the difference between a utility landscape and an industrial landscape?
Well, it's also I mean, it depends on your expectations of where these things are going to be. A solar farm, something which is more and more anticipated to be in a rural area. I mean, you don't expect solar farms to be. It's not really an urban activity, apart from where it occurs on roofs. So I guess it's your expectation as to what I mean, it's like landfills or quarries. They're rural activities, and it's something you expect to see in the rural area.
So you're suggesting that because a solar farm has to be in the rural area, therefore is rural?
It's a solar farm, something you see more and more in it. It's a more and more common activity in the rural area. I'm suggesting it's not. I don't believe it has an industrial character. It doesn't have that. It's a passive. It's a passive activity.
So I want to come back to my question then. What is an industrial character?
I guess it's producing it. It has movement of vehicles.
People.
Yeah. So it's that activity, I guess.
So this has got people and movement of vehicles. Industrial would have structures.
Yeah. I mean, you said this will have vehicles and moving people, but not to the same degree. That's what I'm saying.
Yeah, I mean, I'm sorry to want to keep pushing this point, but I think it's real. This is the crux of a lot of it, and a lot of the submitters have talked about, their feeling is that the activity is industrial and it's an industrialization of the landscape. So I'm really trying to understand why you think it's not. What's the key elements of a solar farm that make it not be industrial?
I mean, I guess your perception of what something is industrial or something that's inappropriate is just your perception of it and how you read it. In my view, these structures are low. They're low-lying structures. They're relatively intrusive in the wider. unintrusive, but also have a light touch on the landscape. You know, to my view, it's something that's industrial has more of a destructive, permanent, more permanent impact on the landscape.
But if we compare, so we've got this visualization in front of us, which is showing a vineyard. So that has structures, rows, posts, that has at times cloth over the top of it to cover from birds. Is that industrial?
Yeah. But it's, you know, I mean, it's, as I said earlier, it imposes a different patterning on the landscape. It imposes a different character on the landscape and different texture, which is why I drew the parallel between the solar farms and vineyards. It imposes a man-made structure on the landscape.
Yeah.
Yeah.
But there's a lot of the submissions are talking about how they don't mind seeing vineyards, but they do mind seeing solar panels.
That's where
Why do you think?
That's where it comes back to perception and of, you know, what an activity is and where it's appropriate.
So your view is that the solar farm is compatible with the rural environment, and it's not industrial.
Yes, in this situation where it's contextual. In this situation where you've got the panels sitting on these individual, vertically fragmented by the terracing, and structured by that terracing and by the proposed revegetation plans, screening, that all that serves to impose a structure which is tied back to the landform, and also will soften it. So not saying you're never going to see it, but it's going to be, you're going to see these panels as islands within structure of vegetation and landform. So in that sense, going back to what you're looking at, yes, in that sense.
I guess what I'm trying to get my head around, and I think my fellow commissioners with me on this, we're trying to really understand, when does it become industrialization? And if you're suggesting that it's not, and that it's meant to be in the rural environment, and it's more a utilitarian activity, and there is a lot of similarity between a solar farm and a vineyard, why would we screen it from view?
Well, that's what I'm coming back. That's what I've just said before. It's contextual. I mean, my view is that it's appropriate because it has got that softening and screening and that structure associated with it. You're tying it back because you're retaining a perception of the landform, and you provide on screening. Then that's when it's appropriate. I'd say there would be occasions where it isn't acceptable, where the solar farm is a more imposing feature on the landscape.
So you're saying the screening is acting as a softening rather than a screening?
In this case, it's partially screening in this case, but I mean, it's sorry. At the moment, I'm thinking of it in terms of the views from the north and the west. So you're kind of looking across this. It's a bit different where you're on the state highway, because it's just a dominant element in the foreground there if you don't screen it.
Right.
So again, yeah, contextual on how you're seeing it.
Okay, I think we'll probably leave that there. I think in terms of thinking about sort of perceptual, let's look at more associational values. You know, associational values aren't necessarily about what you see, it's about how you connect to a place. And there's a lot of the submitters talk about the identity of Waipara and what it means to them to live there. It's not about whether they necessarily see the solar farm. It seems to me that they're coming from a position of knowing that it's there, and therefore that changes their connection with the place. Would you agree that that's where the submitters seem to be coming from?
Yeah, no, I agree with that. But as I was saying with the perceptual thing before about, what's appropriate where, those types of associative values are also fluid. I mean, I don't know how long the vineyards have been in Waipara, but before the vineyards, people wouldn't have associated the tan with grape growing, obviously.
Okay. So that's just talking about sort of a long-term change to how people connect to a place.
As land use changes, so people's perception of the landscape changes.
So do you think the solar farm will change that perception and change people's connection to this place?
Potentially in a positive way. I mean, research has shown, I mean, and this is getting very vague now, people have a positive attitude towards solar power. It's kind of seems being a green and yeah.
Well, there's a lot of submitters that are saying that they don't have that. And
I know that's why I paused them, because there's obviously splits in it. There's a spectrum of opinion.
Yes. And in terms of cultural, and I mean mana whenua values, I understand nothing's recorded, and we heard Mr. Andrew say that there hasn't come anything of that. I mean, I know you've considered perhaps on a broader level, but do you think there is an associational value connected to mana whenua cultural values across here that might be impacted?
It's hard to comment on that. I haven't been made aware of any of those values or associations with the landscape.
Have you sought them out?
Not personally.
Right.
The team has.
Okay. So I mean, just putting all of that together, where you've got your physical changes. You've talked a little bit about the terracing. We've talked about perception in terms of, is it an industrial utility? Does it fit with real character? And then this idea that actually the solar farm might change people's connection to the place over time. So all of those things were considered in your assessment and led to your overall conclusion?
As I said earlier on, I mean, my assessment has evolved over time, and it's kind of arrived at the evidence. So in terms of the evidence, yes.
Okay. And just thinking about those terms, and I guess particularly want to focus on that associational change where you don't necessarily need to see the proposal. And I think also some of those perceptual changes, which we didn't really touch on, but things like the sound of construction, maybe the presence of dust or the movement of different sorts of vehicles. Are you still of the opinion that within 5 years that will diminish? That there isn't a higher level of permanent effects, particularly in regard to associational effects?
In terms of perceptual, yes. I mean, there'll be construction noise. That's something which will last for the construction period. I'm not aware that dust is going to be an issue, and the ongoing noise isn't an issue. I'm advised. The movement of vehicles and the activity within the site will be very low. It's maintenance vehicles, and so no more than less than you would expect on a farm. many associational things are a bit different because, I talked about, this fluidity of association. And, that's not something which is predictable or measurable. But certainly I believe that diminishing of the level of effect over that period, I believe is correct.
And so part of that is, well, a lot of what you're saying is that'll happen because the planting grows and it beds in. But based on what we've also been talking about, part of that reduction in effects is also because people have got used to it. That's the associational element that they've come to accept it. Is that what?
Yeah, that's well.
Okay. All right. Let's just dive in very quickly now. I want to look at visual effects and in particular. And I know you have been through this recently with Miss Annan. I just want to confirm, so we talked about earlier in terms of your scale and it aligns with Te Tangi Ata Manu in terms of that scale.
Oh, yes.
Yeah. So that would mean that when you identify properties in your effects, I think it's your appendix 2 to your evidence. The two properties that you have identified there, which I think are 247 and 253.
Yeah, 253/251.
Yeah. And I know you said only one of those are submitted, but those two properties you've identified as high. So that would be equivalent to significant in terms of the scale that we use.
In this situation, I'd say so.
Yes. Okay. And I think if I got this right, there are 3 properties that you have as moderate to high. 73 Mackenzies, 161 and 163 Mackenzies. Have I got that right?
Yeah, that sounds right. Just pull up the document. So just to clarify, here, I did notice before, I've said, when I've said moderate to, using the word to moderate to high, that's as part of the 7-point scale. I noticed on Miss Annan's comparative table, she's used that wording, moderate to high, but also sometimes moderate dash.
That's high.
So that's a little bit confusing, but just.
Yeah, okay.
So yeah, moderate to high on 73 Mackenzie's Road.
So all of those properties are essentially to the north. And probably the easy one to look at is 247 Mackenzie's because you have a visualization from there. So if we can have a look at, again, I think the zoomed in element of it is easiest, 247A.
Yep.
So that for that property, 247 Mackenzie's Road, you say that that property is high at the construction of the solar farm, and that within 5 years, it reduces to low to medium. Is that right? Yep. So if we look at the 247 visualization, planting year 5, and as we've talked about, that planting is perhaps a little to be desired, let's say, both the boundary planting and also the internal planting. But that's at year 5. So you're saying that at that point is when the visual effects for that property will diminish from high to low to medium. despite there being quite wide views of panels.
Yeah, no, it's because that planting is providing fragmentation, we're still maintaining those long. There's a change in that midground, but because that planting is providing that fragmentation. Yeah.
So you're comfortable with your assessment on that? Okay, and I'm assuming, I mean, we don't have visualizations from 73 or I think 161, and then we got a 151. Don't we? That'll be similar for those properties that,
Well, not quite the same because the separation.
is a bit greater. But that screen planting won't actually screen views of the panels. Because,
So sorry, what's screen planting?
well, in any of those properties, because they're slightly elevated to the north, they look down across Wicket Creek, down to the lower terraces. That screen planting in any of those, which is going to be maintained to 5 metres in height, won't actually provide any screen planting of the panels from those properties.
Not for those, not necessarily for those. A little bit for the front end, but that's only for the lower terraces. They up the balance of the terraces where as they rise up.
Yeah.
Will be screened. So it's only really that you're looking down on the terraces closer to the river.
We need some.
So really the mitigation for those properties, as you've been saying, is the terrace planting, the native terrace planting that comes in between the panels, that helps break them up. Because the screen planting is only really going to do some of the lower properties. It's not going to screen it.
No, there's wherever there's a terrace, there's screen planting along the top of the terrace.
Well, let's look at again at 247A at planting year 5. And we assessed earlier that planting has been modelled at the full height, 5 metre. It's not providing screening of the panels.
Well, it's providing screening of the closest panels.
But not as the solar farm as a whole.
No.
No.
But there's also, but as I say, I mean, in that image there's three bands of panels.
Yeah.
Each one with the terrace and with screen planting.
The internal screen planting.
Yeah, and the internal screen planting, as you go further away, is screening more and more as the terraces step up, is screening more and more of the solar panels on those terraces.
Yes, I think perhaps the terrace, the top terrace at the back, I think I could probably see that a lot of the panels are screened by that top terrace, and that makes sense to me because that top terrace is probably a similar elevation to where the photograph's been taken. So you're looking across the landform rather than down on it.
Yeah.
But those lower terraces, the screen planting, even the internal screen planting, is not screening views of the panels.
It's screening views of some of the panels.
Some of the panels.
Before it's softening rather than necessarily screening.
Yeah. So what we're saying is that your assessment of the effects on this property, for example, moving from a high category to the lower category, low to moderate category, is really because the native vegetation planting, as well as the internal boundary planting, comes up to start softening those terraces and providing the delineation between terraces.
To a limited extent, yeah. I mean, the terrace riser planting is only really expected to provide additional softening screening after a number of years.
Okay, so I'm still, so you're saying it's only the internal planting, the internal boundary, internal screen planting. And as shown in that viewpoint 247A at its full height, that's the mitigation that reduces the effects on that property from high to low moderate.
Yeah.
Right. Okay. And then if we could perhaps just turn to the Weka Pass Railway visualization.
Weka Pass was right there.
Okay. So I think it's fair to say that from this location, quite a large area of the solar farm is visible. And so it's the same question that you're indicating that the internal screen planting in these images is what reduces the effects over time.
Yes.
But in these images, that screen planting tends to be running, you tend to be looking down the screen planting rather than 90 degrees to it.
Yeah. And again, this viewpoint provides more of an understanding of what I'm talking about when I'm talking about the terracing and the planting forming a structure within which the solar farm sits. Also bearing in mind from this view, can you see the access road which kind of runs diagonally?
Yes.
Yep. So the middle band of panels there to the right of that, to the right,
To the left.
That's where the
Matagari was.
Matagari.
Yeah, to the left. Yeah, correct. Yeah. And so I think at your paragraph 223, you say that the effects from this location will diminish to very low to moderate, which seems like quite a wide range.
Which paragraph was it?
It's the very last paragraph of your evidence, which is a good sign because it means it's my last question. 223.
Yeah, that
Diminishes to very low to moderate. I mean, there's quite a big range.
That very is an extraneous word. That should
Okay, so that's low
to moderate.
Low to moderate or low dash moderate?
Low to moderate.
That's still quite a wide range from a single viewpoint, wouldn't you suggest?
No, low to moderate as in
On the 7-point scale, low dash moderate. Yeah.
no.
Not low, not moderate, in between.
Yeah.
Okay. All right, that's me done. Thanks. Okay.
Yeah. I'm starting a fair way through your evidence. So I probably won't have quite as many questions. You reference in paragraph 110 to any impingements on privacy is unlikely from the solar farm. Is that any better or any worse than a farming activity in terms of privacy? Or the same?
But certainly not noticeably better or worse, I wouldn't say.
Okay. And then in the paragraph that follows, I think, and these paragraphs, you're obviously commenting on policies. And I just think, just rereading paragraph 111, I think the reference to the compatibility with existing development might have been taken out of context of what the policy is actually saying. So the policy was as policy 354, and it says to achieve an appropriate level of compatibility with existing development within the surrounding area. I think what you're saying is that it's a solar farm and there's nothing to compare it with from a compatibility point of view, which is not the same in terms of what the policy is saying. So the policy's asking, does it achieve an appropriate level of compatibility with existing development within the surrounding area? So does the solar farm achieve an appropriate level of compatibility with the surrounding area?
And I go on to talk about.
Yes, I know you go and talk about the vineyard afterwards, but it's I guess it's the as such, there is no possibility of incompatibility with existing development. This is what I'm asking about.
Yeah. I guess that's qualified by the.
Yeah, so you've gone on to actually qualify that, so that's not quite correct, is it? Okay. I want to ask you, we spent a bit of time on the compatibility with this comparison with vineyards, and I just want to ask you about the visuals which show the vineyards without any vines and leaves on them, and how you see. I think the best one is 55B. And you have a vineyard in the front, which is lost all its leaves. There's essentially no grass, linear posts, and you can sort of just see the vines, and you can see the solar farm in the background. And I'm just wondering, how do you compare those two from a visual point of view?
Well, I guess my point earlier about patterning and structure and imposing that patterning and structure, that applies here. So it is imposing a patterning and a structure which is man-made rather than natural.
Is that more in this visual? Is that more emphasised because the leaves have been lopped off the vines?
Yeah, to some degree, this without the leaves and without the vines being particularly visible, that texture is quite light, but it's light. It's more emphasised more in terms of its verticality. It's low verticality, but it's quite light. Once you get vegetation on there, I was noticing driving in this morning, looking from the state highway, you still it has more solidity. When the vines have vegetation on them, they have more solidity, but you still see that kind of corduroy patterning. which is something that is apparent when you see the solar panels as well. So, you know, the comparability is there in both situations with or without vegetation. It's just without vegetation, there's more of a kind of an airiness or a spaciousness to the spaciousness. That's not the right word. Yeah.
Okay. Do you think the acceptance of vineyards is higher just because it has plants? It grows out of the ground, whereas a solar farm doesn't. Is that the fundamental difference?
Partly, it's also the health association with I guess lifestyle. I suppose in terms of you think of the other two great group, the Waiheke, and yeah, it's a kind of a there's a I'm trying to think of the word. So there's a lot of associations tied up with the growing grapes or olives or those sorts of.
Even perhaps nowadays hops, things like that, where they are quite substantial structures.
That's right. Yeah, in terms of the structure, I was thinking in terms of the associations and how people perceive those.
That's the issue here that I think.
Yeah, so we like drinking wine, we like eating olives, so therefore we appreciate them in the landscape more. But would you not run that argument to, well, we like renewable energy, so therefore, but it doesn't seem to hit in the same way for some reason.
Again, I mean, I was saying it's a fluid thing. I mean, maybe in 20 years' time it will.
You made reference to the solar farm being a benign rural land use activity, and the site will continue to be grazed by sheep. Ultimately, the existing pastoral character will change to some extent. Is that change in character a negative change in your view?
So you just say that.
So is the change in character, you said there will be a change, the solar farm will introduce a change in character, ultimately, but it will continue to be grazed by sheep, but ultimately the existing pastoral character will change to an extent. And my question was, is that change in character that you refer to there a negative change in your view?
No, it's not negative, no. I mean, the landscape retains a productive capacity. But I mean, it's just as I was arguing before with a change in land use to vines, change in character, but it's not a negative one.
Sorry, so a number of my questions, Mr. Commissioner Bray's already asked, and I'm just having to work my way through these. I just want to check whether this has been done. So I'm at your paragraph 209, and you say there you consider it unhelpful to base opinions of the likely success of native planting on observations of plants and properties nearby. without also providing details of the site preparation, plant source, implementation methodology and maintenance technology in these observed situations. So in the context of what's proposed here, are all these elements that you refer to here going to be in the LVMP?
Yes.
But you acknowledge that there's some areas that still need to be picked up in that.
Well, I see the conditions as being a work in progress.
So I guess it leads us to a question, and I guess the two planners need to be looking at this. Well, when are we going to see some of that modification occur? That's something we need to address, because you've observed that there are some changes that are needed, or even some amendments or some additions. So we need to see those at some point in time. So I'll leave that open, but that does need to occur. We just can't leave it hanging.
Oh, no, absolutely. I mean, it's something I saw works on over the process of the hearing.
I think Ms Anna needs to be involved in that.
Yeah.
Also.
Yep.
Yeah.
Yep. Well, I think all four of you.
Yeah.
Let me just check. Anything else? Yeah, I was just going to ask you about the week of past visualization. And you've got moderate, low to moderate. Is the limited times that the train runs and the changing nature of using the train, i.e. different people each week, factored into those categories? Or is it simply one visual consideration across the whole? It's a bit different from a residential property, isn't it?
Yes, it is.
Because A, it's only running, I think, once a month. B, could be different people every time.
Yeah.
How do you factor that into those, to that moderate, low to moderate?
No, you are correct. I mean, you need to take into account the sensitivity of the individuals who are seeing it, which is why you place more emphasis on the higher sensitivity for residential viewers who are seeing it all the time. With the train, though, I mean, it only runs occasionally and has a limited number of people over the course of time who are going to experience that view. But people are going on that train to experience the train in some cases, many cases, but also the landscape and part of the one of the major contributing factors to people's enjoyment or experience of that is that changing landscape as you're moving through it. To tourist things, so people are going to.
But there's likely in that situation to be a greater degree of variation of views, isn't it, than there is from the individual landowner who's looking across.
Yes, yes. I mean, and I think as I said in my response to your 6 minutes, it's really only that it's only when you're heading back to the Glenmark station, and it's to that one particular point or over a distance of sort of 300 or 400 meters that you really experience those views. So it's over a relatively short duration, but it's quite an important moment when you're coming out of the pass into the valley landscape. But again, once the rawness has gone from the edges of the solar farm. It's set with a planted framework. I think it will sit within the valley landscape and like a vineyard.
I do have another question, which actually I forgot to ask you. Came to me at 2:00 last night. Would you say that the solar farm is temporary or permanent?
Consents for 35 years, so I guess in that sense it's temporary.
Temporary over, so overall you'd say it's temporary, even though 35 years is a long time.
Yes, but permanent suggests in perpetuity. And also it's, you can pack it up and go away and you've got pasture back.
Right, okay.
Okay, that's all. Thank you.
Thank you very much.
It is here.
Who are we looking at next?
We've just had one expert say he's not available after 4. So we're just going to call Mr. Hanmore to see if he can come in now, followed by Peter Ibbotson and then Nick over in Australia. Dr. Bramley is the one who's not available after 4, and I can't see on current progress that you're going to get through him before then. So I'd propose we call him in the morning when he can be available.
I have a few for Gary, but none for Henmore.
Yeah, I've got a couple for him.
If both currently online,
Sorry?
if both of them currently
We
online.
could push through with Gary now.
You want to try, how many questions do you think you can get through, Gary, in an hour?
I think so.
Yes.
Okay, let's go with Gary Bramley. He's there. I might have just
Cut him off at the pass.
Kia ora, no, I'm here.
Oh, thanks, Gary.
Okay. Afternoon. I'm Jimmy. You can hear us, Mr. Bramley?
Yes, yep, I can hear you fine, thank you.
So we've read your evidence, and up to you whether you wanted to summarise that for us, or we can go straight into questions.
I have written a summary, but I think we can go straight into questions if you want to.
Yeah, we're comfortable with that one.
I'm comfortable with that.
Okay.
Do you want me to kick off?
You can kick off, yeah.
Okay. So can I just take you firstly to your paragraph 23? And you talk about the site contained some potential habitat for fauna, including lizards, birds, and bats.
Mhm.
In your experience, should that be assessed as to whether they're there?
Yes, it's difficult with respect to lizards, often being able to detect them even when they're present. So the conservative approach is to assume that they're there and provide for their management, because it's more likely that you find them when you're doing works. And we have done bird surveys as well. Bats too. There's a limited season for detecting bats during the warmer part of the year. And again, with both lizards and bats, you can identify the types of habitat that they use, and when those habitats are present, it gives you a reasonably good indication of whether they're likely to use a particular site.
Okay. With the lizards, just sticking with the lizards, would we be looking at a relocation?
Yes, a salvage and relocation to an area within the site.
Okay, within the site.
Yeah.
And does that necessitates a wildlife permit?
Yes. Yep. A Wildlife Act authority.
I know we have a lizard management plan and the condition, but I just wanted to clarify those couple of things on that one.
Mhm. Normally, the normal process is that you finalise the lizard management plan and it accompanies your Wildlife Act authority application, so that the decision makers at DOC are clear about exactly what you're proposing. And in that lizard management plan, it would specify the location and any activities that you might be doing at that location, such as adding piles of boulders or piles of logs to provide additional habitat.
Is there a likelihood of a confidentiality agreement required around this?
I wouldn't think so.
So we're not talking about probably rare species then?
Well, any lizards are subject to collectors trying to collect them, unfortunately. But yeah, no, they're not nationally critical or threatened species, no.
Okay. Can I just go to paragraph 31? And you've taken us through the effects on fauna in there, and you reach conclusion at the bottom that this is equivalent to a not more than minor effect. So what would a less than minor effect be, equivalent be?
The reason I've used the words not more than minor is that's the EIANZ, their interpretation of the good planning guidelines is that when you get to a position where the effects are very low, the words they use are not more than minor.
Right, so that's not the RMA, not more than minor that you're talking about.
Well, no, it is, because it's there and it's there. They've cross-referenced that across with the good planning guidelines.
Okay, I see. Yep. Okay. So getting to paragraph 34, and this is where you talk about the offsetting.
Mhm.
Now, as you're no doubt aware, we've had this issue with the loss of the Matagori
Yes.
having occurred, and I'm not sure whether you were aware of that prior to writing this or not, that was an issue, but I'm assuming that you possibly weren't.
Mhm.
But having that knowledge now, does that change your view in terms of the necessity for offsetting?
Um, it's a bit, and you've heard these arguments already. It's a bit hard to separate now that that's been taken out of this application and is the subject of something different. It's a bit hard to sort of speculate about what the outcome of that might be. But normally, where there is a clearance of Indigenous vegetation that is non-complying, you normally would enter into some kind of offsetting.
And this is a difficult question, I know, but have you given any thought to what that might be in the context of this?
Well, the obvious thing is to replace the vegetation that was lost with similar vegetation via planting. I haven't given any thought to what type of ratio or anything like that because I'm not familiar with what the vegetation was like before it was removed. But yeah, that would be the obvious approach.
I guess it's probably not the first time something like this has occurred. Have you come across some of these situations before?
Yes, I have actually.
And what were the outcomes there in terms of was the replacement planting provided and at what type of scale?
I can think of two examples off the top of my head, and one was specifically relating to Matagari and other similar dryland type vegetation. In that instance, there was formal protection via covenanting given to areas of similar vegetation that where the ratio was about, I think it was about 5:1. I'd have to go back and check that, but it was reasonably high. In the other instance, it wasn't Matagari vegetation, and it was in a wetter climate. And in that case, it was planting. Actually, thinking of another example, in a gumland, which is not really similar to Matagari, but it was a similar type of situation where some vegetation had been cleared by a district council, actually, who didn't have consent for it. In that case, there was again formal protection given to areas of similar vegetation. It included more than one vegetation type, and there was a range of ratios from 1:1 to 1:10, with the gumland, because it's a naturally uncommon ecosystem, being the highest, which was 1:10.
Okay. Can I just take you to your paragraph 60? Because I'll ask you may need to rethink the first sentence there, given where we're at now. So you talk about the restoration planting and terrace rises will result in a net gain for Matagori scrubland, which will be enhanced through the proposed planting.
Sorry, did you say paragraph 60?
60, yeah.
Yeah.
So that first sentence.
Yeah. It probably will still be a net gain because even taking into account in terms of extent, even taking into account the area that's been cleared. I understand from what the legal advisor for the community group that spoke this morning, she was saying it was more than 5,000 square meters, in the order of a hectare. On that basis, it is still a net gain in terms of extent. There will be a decrease in terms of value for some time until the quality of that vegetation reaches the quality of the vegetation that was removed. But in terms of extent, it's still a net gain. When I wrote this, I obviously wasn't considering the clearance that's already been undertaken.
Yeah, we're cognizant of that. So overall, do you think the biodiversity enhancement, is it an offset in your view, and will it achieve a no net loss?
It is definitely an enhancement, providing that vegetation across the terrace rises provides for much better connectivity across the site and ecological integrity. In the medium to long term, I think it would more than offset the vegetation that's been removed. But in the short term, as I said before, there's some issues with the quality of it is not going to be as good as what was removed until the vegetation has a chance to age and achieve that. There are some things that would be better. The diversity of species, for example, will be higher. As I said, the connectivity in particular will be quite a lot better.
In your view, are the widths of that planting along the terraces, is that sufficient to enable that connectivity to occur? Will birds, other animals, lizards move along that corridor? Is the corridor of sufficient width to enable that to occur?
Connectivity happens at a range of scales depending on what you're talking about. As you've sort of correctly alluded to, lizards operate at a different scale to birds, and birds operate at a different scale depending on what species you're talking about. If you were talking about New Zealand falcon, for example, they have really large home ranges. If you're talking about a bird like a fern bird, which is not one that we have at this location, but they have really small home ranges that can be as small as 20 or 30 meters across. So the main issue with respect to connectivity for lizards is the presence and abundance of lizards currently, because there's no pest control or other lizard positive, for want of a better words, actions going on at the site. If they are present in those areas, or if they are moved to those areas as part of the lizard management, then yes, certainly they would move across those. They would be wide enough for them to move across.
Thanks, Mr. Brownlee. I just want to firstly look at Weka Creek.
Mm-hmm.
And so your understanding from the site plans is that the proposal is located fully outside of the Weka Creek tributary?
Yes.
Yeah. And you then go on to say, I think it's paragraph 89, that the ecological value of the creek is very high.
Mm-hmm.
but it does consist of poplar and willow. So I just want to, can you just give me a very quick overview of how do you get to very high with the exotic species there? Just what's the process?
It's the presence of the threatened and at-risk birds that are still using that area despite the fact the vegetation's rubbish.
Right, okay.
And braided river habitats, which the bottom part of Weka Creek is, are naturally uncommon ecosystems. So they naturally make up only a small percentage of New Zealand's land area. And so even poorly degraded ones are still valuable from an ecological point of view because they're rare and they provide habitat for things like braided river specialists in terms of birds.
Right, so then when we get to suggesting that the ecological value of the solar farm site is low, that's because it sits outside of that corridor.
Yes, yeah.
But what we're talking about is potential for enhancement with corridors to be established within the proposal.
Yes.
Yeah, thank you. And so let's just talk about the planting. Mr. Cocker indicated he had quite a lot of reliance on you in terms of understanding plant mix, etc. Have you had a chance to look at the landscape management plan?
I have, yes.
So in that table on, I think it says sheet 2, there's a terrace riser restoration mix.
Yes, I haven't got it in front of me, but I recall seeing that, yes.
Okay, I just wanted to firstly understand whether you felt that mix was correct, whether that would achieve the ecological outcomes that you're promoting will happen with the mix that's promoted there.
Yes, I think this, as you've already alluded to, this is a difficult site for restoration. I think the focus should be on establishing plants that are likely to survive and persist. The movement of there'll be seeds in the seed bank still, which will come up as other things grow and create the right conditions for them. There'll also be things brought in from outside the area via birds and wind and so on. So really, the focus in my mind in the planting is establishing a cover, an Indigenous cover that allows other things to come in and join the party, as it were.
Yeah, that makes sense. And would you have an opinion on where those species should be sourced?
They should definitely come from as close as possible to the site. And beyond that, they should be from within the same ecological district or the same ecological region, and sort of a hierarchy of preference.
Okay.
So ideally, you know, it's quite common in restoration projects to collect seed from the adult specimens that you have at the site, because they're obviously already locally adapted, and if you can get viable seed, it's more likely to be successful.
Okay, and now that is not covered in any of the conditions that I'm aware of, is it? You may not have seen the update. I haven't seen it, so that's...
I remember seeing it somewhere, but I can't put my hand on just where at the moment.
No.
But it could easily be added to the conditions that the plants are sourced from the Waipara Ecological District or the
yeah,
I forget what the ecological region is, but one of the adjoining ecological, this site is sort of at the corner of several ecological districts. It's in the Waikare one, but those other ones would be suitable as well.
Yeah. And in terms of propagation, I mean, a lot of the species on the list I can see should be relatively straightforward. The one I'm not familiar with is the propagation of Matagari. Is that relatively straightforward to propagate and plant?
I haven't done it myself, partly because I live in Northland and it's not not endemic to Northland. But I have seen it propagated in a couple of nurseries.
Okay.
And as far as I know, it's achievable.
Right.
I've certainly seen it, you know, flowering and setting fruit, which is sort of a first key step to being able to find the seeds.
Seeds, yeah. And just to round out, I think, of the irrigation question, and I think in response to the feedback from Mr. Rees and his attached report to Mr. Cocker, what's your take on providing irrigation for the revegetation planting?
I do think it's probably going to be necessary initially. And you will have read in my evidence, I recommended that the planting be staged based on my experience that, you know, often anything that can go wrong in a planting will. You'll plant it and then you'll get a snowfall, or you'll plant it and then you'll get a drought, or you'll plant it and then the cattle will break through, and so by staging it, you spread that risk so that not everything is affected by the event that happens straight after you plant. And I do think irrigation is going to be necessary initially, but I also think you don't want to create a dependency on water, you know, for the reasons that I think Mr. Rees has talked about. You know, it'll encourage other species that are not suitable for the site to establish and outcompete the ones that are. So it's a balancing act, but I don't think it's impossible.
So what level of maintenance would therefore be required to ensure that that doesn't occur?
I would be looking at probably twice yearly weed control for the first, depending on how fast your growth rates are, probably the first 3 to 5 years.
I think Mr. Manley's invited himself to the rewording of the conditions. Yeah, thank you. That's all I had. Thank you. Oh, hang on. No. I think I remember. Who's got to?
Yeah. Okay. Okay. Look,
yeah.
Thank you, Mr. Burnley.
Thank you.
Thank you.
Rachel, thank you. Yeah, who we got? Oh, no, we've got the short one, haven't we?
Yeah.
Who's online?
Have you got someone online now?
We may have Mr. Hamill
Oh, yeah.
online.
Okay.
Let's do him before.
Yep, we'll do.
Yes, online. Hello.
We can hear you. Just give us a second and right. Good afternoon, Mr. Hamill. I don't think we've got too many questions for you. In fact, I'm not sure Mr. Commissioner Bray's got any questions, so it's all down to me. Look, happy for you. Do you want to read through your summary first?
Well, if you want me to, and it's beneficial, but otherwise I'm happy just to go straight to any questions. But yeah, whichever you prefer.
Well, we can read through your summary anyway, so maybe it's pretty much just looking at questions. So just bear with me a second. There was somewhere. Here we go. Okay, so I'm quite a way through your evidence, and the reference you made to the field trials of the site in Marlborough.
Yep.
What paragraph?
Paragraph 68. And were those tracking panels or were they fixed panels in that case?
Oh, it's a good question. I want to say they were tracking panels. I'd have to check, but I want to say they were tracking panels. Yes, because the Massey one I looked at was they're fixed panels. I'm pretty certain these were tracking panels.
Okay. Just aware that was one of the first solar farms, wasn't it? That one.
I'm not sure. Sorry, no, I'm not sure.
I think it was, and that's where hence the reason for my question. So yeah, it'd be useful if you could find that out. My second question more or less relates to that. Do the tracking panels make quite a difference to compared with fixed panels?
Well, research wise, I have. There's not heaps of research around it. Looking at the preliminary stuff from Massey, quite possibly they're saying 84% drop in pasture production under those panels, but a 38% increase in between. But that also will have something to do with the being a high production site as well. So you get a greater drop in the pasture production under those ones. The Marlborough site I thought was quite comparable, so I thought it was quite a good site to look at. And there's always going to be the loss under the panels to some degree, but yeah, in a dry site offset by the moisture retention from the solar array. So yeah.
So how much of the loss in productivity is dependent on the type of grass species that is there at the time?
I haven't read a lot of research on that particular topic, but I would imagine that it would make sense that a shade tolerant species would do better than one that's not so tolerant. But at the dry site, one of the big things was the moisture retention that they found. Well, that's what they hypothesized that's what they believed it was there. But yeah, and like I say, on that Marlborough site, you would have read it that there was no overall loss in productivity at the site.
How much work is going on in this space at the moment that you're aware of?
There is some research definitely that going on in New Zealand, but there's not a huge abundance. I guess it's because it's fairly new, but there is Massey is doing some, and I'm aware of, like I say, some of these bits and pieces, but I wouldn't say it's something I'm immersed in. So haven't got my finger on the pulse of everything. That's all the research that's going on, but I know there's not a huge amount out there at the moment to get figures from. More there's a bit overseas that's been done, but in New Zealand, yeah, it's fairly early days.
Sorry, I've missed one question. I didn't spot this one. So just take you back to paragraph 61. So in this about the construction of the access ways and hard stand areas and that, what happens to the soil that you remove from those hard stand areas and those access ways? Is it stored?
I haven't been given that information for that, so I don't know if they've gone so much into all that detail. I know they'll be using some of the access ways that are already there, so they'll be upgraded. But no, I haven't. Sorry, no, I haven't been given that information. I'm not quite sure what they're going to, what they will do.
So the potential then at decommissioning for rehabilitation is that you might have to import topsoil.
Yeah, that may be. I mean, storing soil for that long. Even if they did stockpile, you're going to have some shrinkage anyway, and so you'd have to import. You'd have to bring some soil back on the site, and so that's really going to depend on how many of them they're going to reinstate or they want to reinstate, depending on what the land use is when it's decommissioned. They might want to keep some of the access ways, depending on what the land use is going to be once they finish, once the solar farm's decommissioned. So, but yes, that if they are having to reinstate that land, then yeah, there will have to be some topsoil brought in.
Yeah. Okay, that's all the questions we've got for you. Thank you very much.
Thank you very much.
No problem. Thank you.
Okay, take a break for 15 minutes. And if we can get back by 25 to 4. And we've got, at that point, who do we have?
Oh, we have Peter Ibbotson, acoustic engineer.
Yep.
And then Nick Logan over in
Australia.
Yeah.
Yep.
And probably in your hands then, because the last expert would be planning.
Yep.
Layla.
Okay. We'll see how far we get. As I said, we're prepared to go.
Gary Brings.
Right. Okay, we're back again. I think we've got Mr. Ibbotson online. Yes.
Hello, can you hear me okay, Commissioners?
Yep, we can hear you.
Yeah.
Very good.
So have you got a summary?
I've got a brief summary if I could read it.
Yep, no, that'd be great. We'll start with that. Thank you.
Thank you. So my name's Peter Ibbotson and my evidence sets out my experience. The primary source of noise from the solar farm will be the solar inverters. Like all solar farms, or like all generation-only solar farms, noise that's generated occurs almost exclusively during the daylight hours when the sun's shining and the farm's generating power. My noise modelling showed that the solar farm can readily comply with the daytime limit of 55 decibels LEQ and the nighttime limit of 45 decibels LEQ, which are the limits set out in the Hurinui District Plan. And even under my worst case calculation assumptions, noise levels at nearby dwellings were expected to be 21 decibels below the daytime limit, which is a significant margin of compliance. I'm aware that there are some recent changes to the proposed design as a result of the Matagaro removal. I haven't analysed this with detailed calculations, but from my review, I don't expect this to have a significant consequential change to noise. And I'm confident the noise limits can still be readily complied with. And I note that minor changes of a solar farm layout or design through post-consent detailed design changes are not unusual. I expect that the solar farm will generally sit below the existing ambient noise levels in the area, and the area is currently already subject to traffic noise as well as other sources of natural noise. Construction, which you mentioned earlier in the day, will comply with the New Zealand Standard 6803 guidelines at all times. And as you already know, the most significant construction noise is piling, but this will be well within the 75 decibel noise limit. Piling on a solar farm proceeds quickly across the site, and it's not in any one location for very long at all. And I understand that Far North Solar Farm proposes to limit piling to Monday to Friday to further mitigate noise. A number of submitters have raised concerns about wind noise, panel tracking noise, impacts on tourism, peacefulness, construction noise, and I've considered each of those issues carefully and responded in detail in my evidence, which I won't go over in detail now, but I would say that wind-related noise is a low risk at solar farms and at this site. Tracking motors are quiet, intermittent, and benign in character. So as noise levels will be low, I do not expect noise to have impacts on tourism or recreational amenity. My assessment's been peer reviewed by Dr. Jeremy Trevathan on behalf of the council, and there's a high level of agreement between us on all key matters. Dr. Trevathan has concluded that noise effects will be minimal. I haven't spoken directly to Dr. Trevathan other than the exchange of a few minor emails, but it appears we have good agreement. So overall, the location of the proposed solar farm is well chosen from a noise perspective. The fairly large distances between the sources of noise and the nearest receivers would result in noise from the solar farm being fairly low overall and well below the district plan noise limits. Thank you.
Okay, thank you. I just note, just before we get on to other questions there, your reference to the piling Monday to Friday is something that's been picked up in the amended conditions as well. It wasn't in the original set that came out. So for anyone who's looking at the original set, that's not there. It's in the amended set conditions. Okay.
Well, yeah, I'll just follow up on that. So that's now condition 35 is what you're referring to, isn't it? All construction works restricted Monday to Friday. No works for Saturdays, Sundays, public holidays.
Yeah, and there is a reference also in the CNMP construction was condition 32. Yeah.
So my question is, at 38 of the new conditions, although I think it was in the old ones, it was 33, there's construction noise limits, which includes times outside of what is said in 35, but we no longer need those, do we? We can just defer to the plan because there's no construction outside 7:30 a.m. to 6 p.m. Monday to Friday.
Is this a question for me?
Yes, it is. Sorry.
So I'm afraid that the conditions that I have in front of me are not the latest set by the sounds of it. They are a set that I reviewed a few days ago.
You might get, have you got access to the JWS?
Planning.
I have access to it if it's on the website.
Correct, this.
Okay.
That's under joint witness statements.
Joint witness, yeah.
Planning.
Thank you. I will just open that now. That's under planning.
Yep.
Yep. So that's just opening now. Okay, thank you. I have those. Right. So the conditions are in table form. I'm sorry, could you just reiterate those numbers for me?
Yeah, no problem. So there's a new condition, condition 35, which says all construction works restricted 7:30 a.m. to 6 p.m. Monday to Friday, no works on Saturdays, Sundays or public holidays. It then goes on, restriction on hours work does not apply to low noise generating activities.
Yes.
Okay, so then we turn to 38. So my question is, do we need condition 38? Or is the appropriate noise limit outside of Saturdays, on Saturdays, Sundays, would be the normal district plan levels?
Well, I think that what the condition is reading as is that they're not prohibiting people from going on site and doing maybe a little painting, but we are prohibiting people going on site on Saturdays and doing piling and other significant work. So I think it would be, if you require this, it would be entirely appropriate to have the same noise limit that applies perhaps on Sunday between 7:30 and 1800 of 55 decibels to apply also on Saturday.
That's the district plan limit, is it?
No.
Well, it does. It is also the district plan operational condition.
Right.
I'm just trying to be consistent with what's currently applied in Sundays and public holidays. If you look down the bottom of condition 38, you'll see that between 7:30 and 1800 hours that the limit is 55. And so you could also apply that on Saturdays. That's an entirely reasonable level of noise. And most minor construction activities won't even approach that, but it's a reasonable limit.
So what you're saying is we should be looking at, and with that condition 35, we should be looking at combining the Saturdays with the Sundays and public holidays.
Well, condition 35, as I read it, provides a restriction to activities. It's fairly clear on the fact that it's fairly clear there's no works on Saturdays, Sundays, or public holidays, but the restriction doesn't apply to low noise generating activities, and it gives some examples. So I'm not sure it's necessary to combine it. Your concern is what an appropriate. Your concern is that there's a residual high limit that still remains on Saturdays. My response to you is that you could avoid your concern by simply changing that limit of 75 to 55. And then that would be a suitable restriction for any of those lower noise activities that are still permitted by the condition above.
Yeah, okay. Yeah, thank you.
Yeah. So all I was suggesting is doing is putting Saturday before Sunday. Doesn't that achieve the same thing?
Yes.
And the other one to note then for you is, which you won't have seen, is condition 39 in terms of C and D, C in particular, which I think is what you were suggesting in your evidence. So you'll see that they've added, it's been including piling being restricted to construction hours on Monday to Friday has been added into C.
Yes, that would seem to be appropriate. It appears to me that it's covered by a specific condition already, but there's no issue with having it in there under the construction noise management plan, just so that the contractor is aware of it and has a specific direction to them not to pile on Saturday or Sunday or public holidays.
Okay, now that we've sorted that out, we'll just see what questions we've got. I guess the one area that we probably do need to discuss a bit is this review sensitivity rule, where I think there may be a little bit of difference between you and Mr. Trevathan. Is that fair?
Potentially, yes.
I'm trying to understand. So if I go to your paragraph 29, I'm assuming what you're referring to there in terms of the 80 metre setback is new dwellings.
Yes, my understanding is that rule.
Yeah, so that's the NZTA rule.
I believe it's based on the NZTA rule, and that it's
it's based on the NZTA rule. Yes.
Yes.
Okay. So I'm just trying to find the rule now. Someone point me to the reverse sensitivity rule. We need to run through that. Remember which one it is, Nicola?
Sorry?
Do you remember which one the reverse sensitivity rule is?
The condition.
And then the conditions, yeah.
It's condition 102.
Oh, well done.
Yeah, it's originally 90.
Yeah, so, yeah, 700, so. And again, can you run us through what your interpretation of this is, and then I'll see if I agree, and how this works?
Of condition 102.
Yeah.
So it requires the noise level of the operation of the solar farm to comply with the noise limits of 55 decibels daytime, 45 decibels nighttime. When measured at any notional boundary of any dwelling that's constructed after the consent is granted. So the key words being constructed after the consent is granted. The intention of the rule is so that if somebody was to apply for a consent to construct a dwelling to the immediate south of the solar farm and effectively immediately adjacent to a solar farm inverter, and they were successful in getting that consent to construct that dwelling, and then they did construct that dwelling, that it would provide some protection to the solar farm over the fact that noise levels at their property would be higher than the 45 decibel LEQ noise limit, which is applied in 101 above. So 55 decibels during the daytime and 45 decibels during the nighttime is an okay standard of amenity in a rural zone. And so it provides for that. It provides for an okay standard of amenity for future dwellings who may wish to construct their houses directly adjacent to a state highway. I think it's unlikely that that will occur. And if they did, they'd be receiving noise levels from the road, which are higher than the solar farm. But nonetheless, it is important that the solar farm has some protection over reverse sensitivity. And that's the intention of the condition. And I believe it will serve, but I'm happy to hear your questions.
So my question is, where does the responsibility lie for determining that? Because it seems to me to rely with the solar farm rather than the person who's putting the house in, which I thought was the intent. It says the noise level from the operation of solar farms shall comply with.
Yes, it's the solar farm is would be required to meet those noise limits at any future notional boundary.
So the requirement then to ensure that that occurs sits with the solar farm, not with the new dwelling.
No, the new dwelling, I mean, you'd be aware of this, but the new dwelling obviously doesn't have any control over the operation of the solar farm. The only thing that the person constructing the new dwelling has any power over is where they construct it. And if they apply for a consent to construct directly adjacent to a state highway and they're successful in getting that consent, then they might also be subject to solar farm noise levels. The only certainty they have is that the solar farm won't be generating more than 55 decibels during the daytime or 45 decibels during the nighttime at their notional boundary. So that's what they can be assured of, because that's what the consent would require.
But if the solar farm, let's say, for example, the solar farm was generating 60 at the notional boundary, what happens then?
Well, then the solar farm would be required to curtail their operation or change their operation or move their inverters or possibly fit some kind of noise mitigation shroud. They'd need to take action to ensure that they bring their activity back within the limits.
But you understand what I'm getting at? This seems to be around the wrong way in terms of reverse sensitivity. It's putting the onus on the solar farm to comply with the 55 at the notional boundary, as opposed to the dwelling to comply with, by insulation or stuff or whatever.
Yes, I understand. And I suppose that is a consequence of putting inverters on the perimeter of the solar farm. Now that's been done to I think, as I understand it, has been done because that's actually the area of the solar farm which has the least effect. It's the furthest from the dwellings that are to the east. And in a way, it's you're right. It's an appropriate response, an appropriate design response to the existing environment. There are other ways to deal with this, and if you wish to take the approach that you seem to be maybe suggesting that we could take, is that that the condition is removed, that there is still essentially only a requirement to comply with the noise limit at dwellings that exist at the time that the solar farm is constructed, and that for anyone who comes later, that they are effectively unprotected, and that they have to I guess deal with the environment that exists after the solar farm has been constructed. I think that's possibly getting into a planning matter here. I guess I would only have concern about the fact that there might be concern over potential unreasonableness or issues raised about even a noise level of 55 decibels if that person didn't have if there was no limit in the consent that necessarily applied to the dwelling. This condition is achievable by the solar farm. I don't believe that noise levels are going to be above 55 decibels at the notional boundary of the dwelling, even if it's constructed quite close to the road. So I don't think it's a significant risk.
Okay, well, that's interesting. I guess my concern is that what it would actually do if the scenario I was talking about played out was actually puts the council in an enforcement position, because the complaint, if not going to go to the solar farmers, it's going to go to the council. The council's then got to take action, whatever that might be, and approaching the solar farm to actually mitigate to 55. There was no other way that process would happen.
That's right. So if there was a limit in the consent and it was, let's say, 55 decibels, and someone built adjacent to an inverter and the noise level, and they suspected the noise level was above 55 decibels, then they could go to council or they could get a measurement and they could determine that the noise level was above 55 decibels, and then that becomes a consent enforcement issue. And I would imagine that it's likely that the council would require the solar farm to curtail their noise to meet the limit. The opposite approach is that there is no limit that applies to a future dwelling. The only limits that would apply would be to existing dwellings. Then there would be no limit. A complaint could still be lodged with council, and council would need to address the matter, I suppose, based on reasonableness of Section 16 of the RMA. It might become potentially a little bit more nebulous. I'm sorry I don't have a clear answer here, but you obviously have significant planning experience, and you will have thought about this probably many times over your career. But I feel that this provides some certainty to the environment, even though it's unlikely that anyone would be building a dwelling there. I believe this provides some certainty over noise.
Okay, look, I think we can sort of, we'll hear from Mr. Trevathan later on, and obviously the planners have heard the discussion around it. The only other thing around this, and legal counsel for the applicant might look at this, is whether such a condition might actually be ultra vires. You need to have a look at that, but I'm just wondering, and given that in my view, I think it does put the council into an enforcement role for a condition, it might not be, might actually be ultra vires. But anyway, that's something that you guys can look at. I've put it out there. It's not for us to resolve, but obviously we can hear from Mr. Trevathan later on the issue, on the matter, and people can come back to us. Let's just see if we've got any other questions, Shannon. I'll just check if I've got any others. That was the main one I had. Oh, just just in paragraph 58, you refer to the dwellings on Mackenzie Road. Excuse me. Which dwellings are more impacted with the piling? Do you know which ones in particular were more impacted?
Give me a second and then I'll answer that question. I believe the closest dwelling to the piling is the dwelling which is to the north of the lessee's property, the dwelling that's on the solar farm. 165 Mackenzie's Road. There's a bit of a cluster there. I believe it's 165 Mackenzie's Road, 167 Mackenzie's Road, and possibly 247 Mackenzie's Road. The very approximate distance to the edge of the solar farm arrays, though, where the piling might occur, even to those dwellings, is going to be in the order of 200 meters. So it's fairly significant.
200 to the closest.
I'm giving you approximate
Yep.
numbers here, but yes, of that order. If you like, I can provide some more specific measurements, but that's my approximate distance to the facade of the closest dwelling as I see it.
Okay. And the other question I had for you is what's the difference between the piling, your understanding of the piling that would take place in terms of the solar farm and the piling from, say, post hole driving in terms of the vineyard?
So a vineyard would likely use a drop hammer on the back of a tractor to ram a timber pole.
Yep.
Yep, thank you. It would be a different source of noise. It would sound different. The levels from the piling which occur on the solar farm are brief, but fairly loud when it happens. If you're standing near it, then certainly it's the dominant source of noise in the environment. It's a higher frequency sound. I'm not almost bell-like. It has a sort of a slight bell percussive ring to it as the pile is pushed into the ground by the piling head. The piling head, as I understand it, is a short throw hydraulic hammer which essentially just pushes the pile into the ground, and as the piles are made of steel, they ring at their resonant frequency, and so it has that metallic character to it.
Excuse me.
So just which the piling of, say, a post hole driver putting posts in for a vineyard, would that be louder than that, or just a different tone?
I believe it wouldn't be louder in terms of the overall level. It would be a drop hammer pile on a timber pile like that using a pretty low energy. The hammers that we have on the back of tractors are not particularly, they don't have a lot of kinetic energy, not like you would get on a construction site when you're doing a significant drop hammer piling rig. And because it's because the hammer that's dropped from the back of a tractor is hitting into timber, it also doesn't really have the same level of noise emission that you do when you get a drop hammer hitting into metal. So it would be a lower level of noise from the vineyard construction.
Okay. Me. Okay, that's all I have for you. Thank you, Mr. Ivinson.
Thank you
Thank
very
you.
much.
Next expert witness is Mr. Nicholas Logan. He is
You on the list?
Only. Your two officers of CJW.
I'm going to try and get hold of him.
Nicholas, was it your after?
Yep. Nicholas Logan. Questions was good.
Yeah.
we just call him we daylight savings.
I have daylight savings just shortly. Sally Queensland, that'll be that. It's Angus will turn 3.
They refer to it management plan and condition.
2 hours.
Don't believe I was told it was
No, I haven't seen it. There was a condition about if Clear came,
They're just trying to phone him now.
Clear came up, there was a condition about dealing with it. Yeah, there it is, 63.
He's 63.
Right.
63. See, he sees, he agrees that it should be an adept management plan.
Isn't it? I think they've just called it a length and glare management plan rather than a damage. It's the same thing.
She's.
Understand. Yes, no, that's.
I think the idea of the adaptive plan is what was covered, which is C, 63C, methods to respond to substantiated glintal glare effects, and how you might do physical alterations to the solar panel layout, installing street light. Maybe that's. I'm pretty sure that's what he's referring to. Else we're gonna just generate.
It's just like students, like, it's like this. It's kept it very.
It's still coming through.
Yeah. Oh, good.
Hello.
Hello, Mr. Logan, can you hear us?
Yes, I can. Can you hear me?
Yep, we've got you. Okay.
Very good.
Now, be with me a second. So you've got a summary statement, haven't you?
Yes.
Okay,
Yes.
do you want to run through that first and then we'll see what questions we've got for you?
Yep, sounds good. So my name's Nicholas Alexander Logan. I'm a project engineer with ITP Renewables. I've been in the renewable energy industry for 7 years, and for 6 of those I've been doing glint and glare studies for our own projects, for development projects, projects in Pacific Islands. I've been involved with this project since November 2023, so I didn't conduct the study myself, but I directed it, I reviewed it, I'm very familiar with the history of it, and similarly with the additional follow-up analysis we've provided since then. The glint and glare assessments are based on a software model called Forge Solar. The model is based on the layouts of the modules that Fine Authors developed over the years, and the model is iterated as those layouts have changed. So it takes in the mechanical details of the plant, the layout, the height of the tracking structures, those kind of things. The model that the latest model includes a 10-degree limit on the array backtracking as the main mitigation for glint and glare effects. And the other part, and then we have the proposed vegetation screening included in the model as a secondary mitigation. The results of our modeling show that there's no yellow glare on any of the roads. Yellow glare is sort of the primary concern we have when evaluating the glint and glare impacts. And that is provided that the screen planning is essentially as proposed at the maximum height and is thick enough and dense enough that it's essentially opaque. There's a small amount of residual green glare, but in my opinion, that's not hazardous and it doesn't require any further mitigation. And so based on the mitigation measures in place, it's my opinion that the residual glint and glare is less than minor. Happy to take questions.
Okay, thank you. Do you want to go first?
Yeah, okay, thank you. I just wanted to confirm, so you have now modeled it with a 10-degree backtracking and resting angle, is that right? Because I think I read it was 3 degrees at some point.
It was 3 degrees in the original study, but it's 10 degrees in the latest version. So it was increased to enhance the mitigation, essentially.
Right. And that also takes into account that it's now a 1p arrangement.
Yes, yes.
2p,
So we made a series of changes at the same time, and that was, yes, reducing the height was one of them.
Yeah. Okay. And also, Mr. Andrews talked this morning about changing the orientation, made quite a significant difference.
Yes, so the original orientation was due north. There was a change that came through where it went to sort of 45 degrees west. And essentially that it means the backtracking mitigation doesn't work as you would expect because you sort of end up aligned with the setting sun. But once we restored it to due north, then that tracking mitigation works as designed again.
As designed, yeah. Okay. Obviously, we've seen the evidence from NZTA that they're now comfortable with everything. No effects on state Highway 7, and I've made the assumption that's for all drivers, is it, including, trucks, buses, etc.
Yeah, so we modeled it at two heights. We usually do, for major roads, we'll do one at roughly the height of a car, and then one at the height of a truck driver. Buses are sort of going to be in between, but those two numbers give you a pretty good indication of what any driver would see.
Yeah, and the screening vegetation. Well, so firstly, the backtracking was the one that resolved it, so you don't need the screen vegetation to resolve.
No, I don't believe so. It's in some cases, screening is required. I don't think we ran a specific analysis with none of the screening that's been submitted as evidence, but I'm pretty confident that it would be. It's pretty unlikely that with such a high resting angle you'll get much glare. Where you're relying on that vegetation screening to mitigate it.
Okay, the only area I just want to double check on that is underneath the transmission lines. There are a number of, I think there's 3 transmission lines that go across the site, and under those transmission lines, the screening has to be lower to meet with transparent requirements. So did you consider that lowering?
No, I don't believe we made a gap for the transmission line. I'd have to go back and check, but I don't think so.
Okay, so that could be a risk in terms of, I mean, it might be small, but there could be a risk through that gap.
Yeah, so the way we'd normally do this, to be very conservative, is we sometimes will model with no screening at all, and that gives you like the worst case. So you're right. If that particular section of road is relying on the vegetation screening, then there may be a risk that there's glare there. I think it's important to note, though, that generally, when the terrain is flat, the backtracking mitigation is most effective.
Yeah.
The only times we really rely on screening is where there's complex topography, either there's a high hill over the top, or the trackers are sloping down a hill on their own. It's in those scenarios where there's big changes in vertical height between the array and drivers, and the arrays are not necessarily horizontal. That's where sort of the tracking mitigation tends to be less effective, and where you rely more on vegetation screening. So I think for this case, for State Highway 7 right next to the farm, most of the glare you'd expect from there would be coming from right next to the road, and that's where the tracking mitigation is most effective.
Okay, I think that helps me with my next question, which was actually in regard to Mr. Trevelyan's comments. Is that his 2.7, which I wanted to ask him about, but I was actually just trying to make sense of what he was saying at his section 2.7. I don't know if can get that up.
I don't have it in front of me, but I remember I remember responding to couple of his points. Which bit of his evidence is that about?
Well, so what he's saying is where landscape mitigation may not likely to prevent glare from a PV array, as was found for PV array 11 and RTO 6 or State Highway 7, the mechanism for such occurrence was noted in the peer review report 4.3, which showed this could be due to a significant difference in terrain height based on the terrain elevation profile.
Yeah, I remember the diagram. Yeah.
Is that resolved, that question?
Well, I think one of the things here is that we haven't updated the modeling to directly respond to the peer review, because we didn't actually receive it until quite late. So after we finished our final assessment, I think there's obviously potential that because it falls away. I mean, he's sort of done a diagram of trying to illustrate how that reflection could occur. The one thing I would note is that for this site, we used LiDAR elevation data, whereas I believe Mr. Van der Velden used Google Earth. Sometimes there are slight differences between those, and the LiDAR data tends to be more accurate. So, and if I recall correctly, he was using a 3-degree backtracking angle. And when we were using that 3-degree backtracking angle, there was more glare. And since we've increased it to 10 degrees, that glare has gone away. And I think that mitigation will have helped with the issue that he identified.
Okay, thank you. In a similar vein, I think there's still just something hanging about the 2-story properties, which, and I think submitter 57 has got some concerns about that. So you're still confident there'll be no yellow glare on the 2nd story?
Yes. So vertical height it does make a difference sometimes, but it's usually an edge case. So generally what we will see if we increase the height of a receptor is if there's glare already occurring, then you just get it for longer periods of time, typically, or else it shifts during the year a little bit. It's very, very rare that you go from no glare to any glare or a lot of glare. And usually when that does occur, it's only very small amounts. So he's right that it does make a difference, but it's not a very sensitive parameter in general. And none of the properties in that general direction receive glare. And I would be very, very surprised if by just increasing the height by a couple of meters that we would see any significant difference. I believe that property, we excluded it from our original study. It seems like that was probably not, that particular exclusion maybe wasn't justified. It's always hard for us to determine exactly what's going on the ground. And if there is a 2nd story, then they'll probably see over the vegetation. The one sort of mitigating or the way that we can get a proxy, you can use the properties in the general direction as proxies because all of the glare is, because it's all angular, properties in the similar direction get similar results, and none of the properties in that general direction received any glare.
Okay, so then finally for me, I think you talk about an adaptive management plan, but in the conditions, I think it's just called a glint and glare management plan. Yeah, same thing. Yeah. And so I think a key part of that is condition, the new number 63. And it talks about, if glare was to happen during, because of construction, maybe it's a minor change. I can imagine the reasons why it might happen. That there would be solutions within that management plan to make alterations to the layout or etc. to diffuse glare. Does that condition capture what would need to happen, and also what could be done in reality?
I don't have the wording of the condition in front of me right at the moment, but what can be done? I suppose there's 2 parts to this. One is during construction and one is during operation. So during construction, the simplest thing to do to avoid glare effects is to not have all the panels pointing in the same direction when they're not operational, because the problem with glare from panels is not glare from individual panels, it's from the whole large group of panels in the solar farm pointing in the same direction. Typically during construction, you're not going to have all of the modules pointing the same way necessarily, and that's a simple way to not have glare during construction. During operations, the approaches you have are, one, you manage tracking, which is what we've done. Two, you could make changes to screening if needed. That's obviously quite hard if the screening needs to be tall. You can, as like a last resort, you can remove panels. I think that's very unlikely that it would be required because the tracking is the most effective way we have of mitigating glare. And yeah, even with the tracking, if there's a particular persistent glare issue, I've heard of cases where rather than a particular set of panels following the standard tracking algorithm, those panels that are responsible for the particular glare issue will be individually programmed so that they don't create that glare hazard. So it's possible to go through tracker by tracker if really necessary, and identify the specific sections that are the cause of the problem and adjust the tracking algorithm to avoid that particular reflection.
Thank you.
I think I've only got one question for you now. And just goes back to your paragraph 9 when you talk about the observation points. And just wanted to ask you whether Mackenzie Road was looked at. Talk about State Highway, Catherine's Lane, and Darnley Road.
Yeah, I believe so. Let me just have a. We included all the roads that were within the 3-kilometre study boundary, unless they were in the town effectively. I'm just going to confirm that though. Mackenzie Road. Let me see. Yeah, where is it? Sorry, bear with me 1 second. I'm just checking the list. Yes, Mackenzie's Road is in the study. It's Route 08. And it wasn't included in the update because it didn't receive any glare originally, I believe. Sorry, it didn't receive any glare after the update. So the update table only includes those receptors that got some glare.
Yeah.
Okay. Thank you. That's all I've got. Thanks very much.
Thank you.
Thank you.
Welcome. Thank you. Bye.
Okay.
Thank you, commissioners. Our final witness, Ms. Leila Al. Afternoon.
Afternoon. You've got a summary, haven't you?
I have, yeah.
Yeah. Okay. Run through that, then we can do questions.
My full name is Leila El Kamel. This statement summarizes my evidence in chief provided on 24th April 2026. My supplementary statement of evidence provided on 7th May 2026. Summary of evidence. My evidence was prepared to provide an assessment of the application in light of the relevant provisions of the Resource Management Act 1991, RMA, and the relevant planning and policy instruments, including the Horonui District Plan, HDP, having regard to the evaluation undertaken by the council officer, Ms. Kirby, and the applicant's experts. The proposal seeks to establish and operate 138 megawatt peak solar farm at 380 Waipara Flat Road, North Canterbury. Consent is sought for a term of 35 years. Overall, the application is considered to be a discretionary activity under the provisions of the HDP. Specific areas of concern for submitters on the application are those relating to landscape and visual effects, ground contamination, incompatible land uses in the rural environment, glint and glare, fire risk, ecological effects, noise and traffic effects. In my view, the application finds support in the relevant planning documents, specifically the provisions under the National Policy Statement for Renewable Electricity Generation, 2011, and the Rural and Energy chapters of the HDP. I consider that the proposed solar farm will provide benefits in the form of renewable electricity, which will enable communities and people to provide for their social, cultural, and economic well-being. Per the evidence of the applicant's landscape architect, Mr. Simon Cocker, while the proposed solar farm will have a more than minor effect on the landscape values in the short term, while mitigation planting is established, these adverse effects are expected to reduce to less than minor. In my view, adverse effects overall can appropriately be avoided, remedied, or mitigated to ensure adverse effects are minor or less than minor over the long term. This is supported by the proposed consent conditions attached to the joint witness statement I prepared alongside Ms. Kirby, dated 8th May 2026. It is my view that there is no planning reason why resource consent cannot be granted for this application. I'm happy to answer any questions. Thank you.
Okay, probably my turn. Okay, I've got a few questions on the effects issues, and some of them we've been through today, but I'm going to pose them to you. I will spend a bit of time concentrating on the various policy regimes through them, and I'll have to come back and ask you a couple of questions towards the end then. So the first one is around the effects, and you heard our discussion with Mr. Coker around the highs. So he's indicated that there are high effects, and these are not just at construction, these are beyond construction. So 1 to 5, where he identified there was 2 locations where he considered that the effects were high. And as we've discussed, that's the level of significant in terms of the 7-point scale. So you've, in your paragraph 59, said that adverse effects on visual amenity values are minor and acceptable in the context of the wider environment, and go on to say that adverse effects can be appropriately mitigated by the proposed shelter belt and mitigation planting. Is that reference to minor in the context of the whole solar farm as opposed to individual sites?
Yes, it's taking
So you're taking a broad view on that?
Yes, I am. Yeah.
So in the situation where we have some significant effects which have been identified, we acknowledge that there's a period of time in there. What period, in your view, is it acceptable for those significant effects to occur? Is a 5-year period beyond construction acceptable for significant effects? And then reach a conclusion of mine.
I think, given the context of this proposal, being a rural environment, and in my evidence, I touch on sort of the rural provisions of the district plan, acknowledging that it is a working environment. I believe it is.
You heard my discussion with Mr. Ibbotson on this noise rule. And essentially, it seems to me that that's a condition relating to a third party. What's your take on it?
I was expecting questions on this. I think it's I've been conscious of trying not to craft a condition that imposes a requirement on a third party. So the condition aims to address reverse sensitivity by putting a restriction on the solar farm. But I acknowledge your points about potential compliance issues being a matter that council has to manage. So I think that probably needs to be fleshed out. But the premise of that condition is to, front any potential issues down the track, even though they may be unlikely, that a dwelling is constructed and then experiences noise effects.
Because it's a bit odd, isn't it? We'd call it reverse sensitivity and then put the onus back on the solar farm.
Yes, it is.
I mean, I honestly have never come across a situation where the onus is going back on the person who's trying to protect themselves from reverse sensitivity.
Yes, I think
Then you got to ask the question: is it actually reverse sensitivity? Because what you're getting to is a situation where the condition, if the condition is breached, it's actually the solar farm that isn't breached. It's not the third party that's breached.
it is, but it is a higher noise level, so it gives the consent holder, in that case, there is I guess a bit of a buffer there because it's a higher noise level than they're expected to breach. So it's been crafted in a way that is trying to not impose a condition on a third party by keeping it to the consent holder. But I take your point. It is putting the onus on the consent holder, even though it's actually meant to address a reverse sensitivity effect.
Can I ask, is it like a virtual noise contour? Is that what we're talking about? Have you come, like in an airport has a noise contour around it that says you can operate to this limit?
So yeah, usually the only way you'd ever see this is through a plan change.
Yes, that's right. So it's not drawn on a map. It's virtual.
It is virtual.
But in this case, it's a condition, not a rule.
Correct.
Okay, look, I think it's something that needs to be fleshed out. And as I say, I'm at this stage, I'm not convinced that it's lawful to have it that way around, but the legal counsel might tell us different. But I think it's something that needs to be fleshed out because it is a strange condition.
Yeah, I take your point on that, and to add to that, I think it may be beneficial if there was focusing on that with the noise specialist.
Yes, well, I think that's correct because my recollection is that Mr. Trevathan might have had some issues with it.
Mm.
I'm not sure whether it was the same as my issues, but okay, I think we're probably going to get into. Oh yes, I think we need to talk about some of these conditions and the potential for overlap with the regional council conditions. Now, contamination is obviously one, and then I think possibly the construction management plan. And I took from, I think it might have been possibly some supplementary evidence that there is some differences between the regional council conditions and what's being proposed in here. I think it's in your witness statement, yes.
Yes, so there are some, you will have seen in the updated conditions attached to our joint witness statement, where Ms. Kirby and I have recommended that there is reference to management plans that sit in the regional consents. However, there's one plan, I think that's the AV fauna monitoring plan, which is a ECAN condition, is very much around tree clearance and doesn't cover broader monitoring of birds over the life of the solar farm. So in that case, we're still recommending a another management plan that would be prepared under the district consent, but also with the condition that the ECAN management plan is provided to district council.
Right. And so what about the contamination and construction management plans? Because obviously they're covering various, things like dust and stuff like that. I get the difference between amenity and discharge, but how has that been dealt with? Is it proposed that the two councils work together through these management plans, or are there reference across to them, or as some of the, given that the ECAN ones are already consented and they're already through, are some of them in here redundant?
I think probably construction management plan, that could be another condition that is a matter of just the ECAN condition or that management plan being provided again to council, because there is probably redundancy in those. In terms of contamination, are you referring to what aspects of contamination are you referring to?
I think it was sitting in. See, I think I was asking myself a question, does that one may not overlap with CRC. I hadn't seen the CRC ones at the time. I'm not sure whether there is one on that one, but certainly on the other ones there were.
Yeah, I think for contamination there's a soil monitoring plan that sits in ECAN's suite, or that just might be the state of environment monitoring plan.
Yeah, the one I wanted to pick up on was dust, because I think the regional council consented, my understanding is that that's specifically tailored to earthworks only. So it doesn't consider dust generation from activities that are not earthworks, like during construction and also operational.
Yes, that's right.
And I think there's a condition here which says that it may not, I think the regional one says it may not create a nuisance. And I think it says something similar here about dust mustn't be a nuisance. I was trying to understand what a nuisance was and how it would be dealt with if it was. I've looked at myself, I can't find anything.
I would. So that's condition 36.
Thank you. Yeah, so not just dangerous offences or objectionable. If there was dust beyond that, is that just become a compliance matter? How is it dealt with?
And who's dealing with it?
And who deals with it?
Yeah, I think that condition should be strengthened to set out the responsibilities. I will say that I don't understand risk of dust effects to be high, given the earthworks proposed, but yeah, just reading that condition again, I acknowledge that needs strengthening to set out the responsibilities. And
yeah, I think part of the problem is we don't have any expert evidence on dust outside of earthworks in terms of operational, I mean, it's gravel roads through the site, so we don't know. So yeah, I think that is looking at. Okay, thanks.
the reference to planting and screening, I just want to tease this out a little bit. You refer to the irrigation and that will be provided for the first 3 years. And has been some conditions brought in on irrigation. What happens if there's plant failure ongoing after that 3-year period?
Well, I think the condition as it currently reads requires irrigation for 3 years and then as required to ensure timely growth. So it may be that it extends out depending on seasonal requirements. How I would expect the landscape and vegetation management plan to work is to incorporate a adaptive management response as well to deal with plant failure and to manage irrigation, particularly noting the comments that have been received about how carefully irrigation needs to be undertaken on the site.
And just to make clear that the irrigation, so because your reference is to screen planting, and then condition 25 just says irrigation, but that irrigation is for all planting. Am I correct?
Yes.
Not just screen planting?
It should be all planting is my understanding.
I think we might have pursued that earlier today.
Yeah, we did, yeah. I think we should bring that consideration of that into the landscape management plan. It's a key part of it to be fleshed out, I think.
Because I think the confusion is rising is the difference between some of the wording in your evidence and some of the wording in Mr. Cocker's evidence is the reference to screen planting and then revegetation planting. But our understanding now through these conditions is it's all planting to be irrigated.
Yes, for the purposes of irrigation, yes.
Which is consistent with what we said today.
Okay, now just going to get into some of the policy provisions here. I just noted in relation to the MPS REG, and you'll heard my questions earlier, that you haven't commented on the objective, which has substantially changed, and policy A, where there are some changes there in terms of what came out in January. So just taking you through those, we've now got musts instead of shalls. Policy now includes the consideration of benefits of providing for social, economic and cultural well-being. So does this proposal do that in your opinion? It also includes recognising the temporary and reversible nature of adverse effects of some REG. Does that apply here in your view? Again, reducing electricity losses by locating REG close to demand and existing electricity facilities. Does that apply in this location in your view?
What would you like me to answer?
All of them, please. So can I take you to policy A? If you go to policy A, I think these are substantial changes, and we need to understand your position on some of these changes. So have you got policy A?
I have got policy.
Yeah. Okay. So C, providing for the social, economic, and cultural well-being of people and communities and their health and safety. Does this proposal achieve that?
My understanding is this proposal will be a regionally significant piece of infrastructure which will improve the resilience of the national grid. And with that in mind, I consider it does provide for the social, economic and cultural well-being of people and communities. And in terms of health and safety, I would also consider it provides for that, looking at the measures in place around construction and operational considerations, including fire risk. So it is my view that it does meet C.
Okay, now what about F? The temporary or reversible nature of adverse effects on the environment of some REG technologies. I mean, it's quite specific. So does a solar farm achieve that?
I guess there's two components to that. First off, temporary. We've heard that there is going to be over a 5-year period effects on landscape values. I would state that would be a temporary effect, looking at a lifespan of a solar farm. And then looking at the reversible nature of adverse effects. For this proposal, a 35-year consent is being sought. Arguably, it is a reversible activity, and there is a decommissioning management plan and measures around returning the site to its previous state. So I would say, considering that, it is consistent with F.
I just want to take that a little bit further. And it's a question of weighting and how much weight would we give this? I mean, you could say that any solar farm has a limit, has temporary and is reversible. You could also say that potentially about a wind farm being reversible. Probably couldn't say about a hydro. So would that mean that, what would your take be? Does that mean that all solar farms therefore should be granted?
No, and I would argue that not all solar farms have a consent duration proposed. Many solar farms that I've worked on have also sought an unlimited duration. I would say the wording of F, it's quite specific in saying some REG technologies. And in that, it acknowledges, I believe, that hydro, for instance, would not fit into that category. Solar, I think, does, but that does not mean necessarily every solar farm application is consistent with F.
Okay, and G, so reducing electricity losses by locating REG activities close to electricity demand and electricity networks.
So taking on board the evidence of Mr. Andrews, who explains about electricity losses and the location of the solar farm being a strategic location for the conveyance of that electricity, I would say it is my understanding that it would be consistent with G.
So the proximity to, say, the Transpowers lines and their substation.
And the grid injection point.
So given that we don't have in front of us a consent or a connection to the grid, how do we consider these benefits? Because it doesn't actually provide those until that connection is provided.
Well, I think, firstly, in my experience, a lot of those connection works, which Transpower usually applies for, they typically can fall under permitted activities. I'm not 100% sure on these utility provisions, but across New Zealand, most utility provisions provide for those connection works when Transpower is the applicant as a permitted activity.
And then just going to H, so reducing adverse effects by co-locating REG and other appropriate REG assets and activities and other appropriate infrastructure activities and locating REG activities to minimise adverse effects on other activities. So the reason I'm taking you through this is because your next paragraph doesn't actually address any of those, and that's why I need to tease this out.
Well, I think in this proposal, it's the location of the substation and that grid injection point, which fits with I in terms of being other appropriate infrastructure and activities. In my experience, solar farms have to be located in proximity to a grid injection point, and that will make or break the proposal. And that's where the functional and operational need also arises. So for this site, it is the location of that substation.
So in the context of that, and if you think more broadly, not just from solar farms, so the reducing the adverse effects, what you're saying is the proximity of the substation means that there's less lines than might be if you're located somewhere else away from the substation and then had to put those lines in. Would something like that be reducing the adverse effects in terms of that co-location?
Yes.
Now, what about the lines that are crossing the site now? Do they play into this, in your view, clause?
The existing transmission lines? Right. Well, they're inherent to a site that is in close location to a good injection point. So yes, when you're dealing with a site that is trying to reduce electricity losses by locating close to a good injection point, you will have high voltage transmission lines typically also in that location.
And just in terms of the reference to functional operational needs and the assessment of alternatives, as you're reading that assessment of alternatives only relates to that functional and operational need provision, i.e., it's not broader, and then it's not broader in terms of saying you don't have to assess alternatives in terms of Schedule 4. Or schedule.
That's correct. It's tied to this. Yes.
You probably heard my question earlier of legal counsel about the word where practical. Do you consider that is in play in terms of policy 5 in this case? In other words, do you consider there are some effects which have been unable to be avoided, remedied, or mitigated, and therefore the where practical comes into play?
Yes, I would agree with that, particularly in relation to landscape and visual effects.
Do you have a question coming from in?
No.
So that sort of takes me into the RPS and your statement at paragraph 60, where you say that in your view, the adverse effects of the proposed solar farm can be appropriately managed in order to ensure potential actual effects are avoided, remedied, or mitigate. But yet you're acknowledging that there are some effects, particularly perhaps in that 5-year period. So just said to us just before, the where practical was in play, and there are effects on landscape and visual. So does that still run true, that the effects are potential, all the potential and actual effects are avoided, remedied, or mitigated?
Where was it? Did you say paragraph 60?
160.
Sorry, read this. And in reading that, I think it should, my first sentence should have included where practicable.
So it can be appropriately managed where practicable in order to avoid, in order to ensure. That makes sense.
It should read to ensure potential and actual effects are avoided, mitigated, or remedied as far as practicable.
Okay, can we go down to paragraph 183, in particular policy 3.5. So now we're now in the district plan. And you don't seem to have addressed the various limbs of these policies here. And I just want to, so I want to take you through those. I've checked back into the application itself and they're not really addressed there either. So I'm just going to walk you through them and then ask you a question at the end. So in terms of those limbs, one is, so the policy obviously reads to enable a variety of activities to occur within rural areas while managing adverse effects on character and amenity values by seeking that the scale and siting of development, one, maintains a dominance of open space and planting over building, especially when viewed from public places such as roads. Where does the application stand in relation to that?
Well, how it's worded is, I would argue is not, it's not really considering a solar farm development. I think when the word buildings was used in this policy. So in that context, it's my understanding that this proposal will change the character of that rural environment. And it will, where there's a dominance of open space that might seem to reduce, but it's not in the league of a building or large scale subdivision or intensive housing development. So in that, with that view, it will still maintain a general dominance of open space.
Would you say there's an element of inconsistency with that particular clause? No.
I wouldn't say it's inconsistent. I would say it's, I find it slightly confusing reading that and sort of trying to understand what is trying to be achieved by that provision.
I think I can probably help. I think where it comes from there is there's a difference between what is rural and what is urban. In an urban environment, you would anticipate buildings, and in a rural environment, you would anticipate open space.
Yes, and I think that goes back to my point that it doesn't envision a renewable energy project such as a solar farm, which doesn't fit in the camp of urban. And will change that, will be a change in terms of the landscape character, but whether it's dominating that open space, I'm not sure.
And then, so turning to 2, which maintains privacy and rural outlook for residential activities.
Well, in terms of privacy, I would argue it does, and arguably it is perhaps going to be more private than a farm. I say arguably because I'm not putting that farms a reduction in privacy, but I understand an operational solar farm has few staff that need to come into contact with it. In terms of the rural outlook, I think what a rural outlook is something that is to be debated, particularly as solar farm developments become common across New Zealand. And presently, a rural outlook probably doesn't include a solar farm, but in the next 5 to 10 years, I would argue that will change.
In terms of that policy at the moment, what would you say is that rural outlook for residential activities maintained as the application stand?
I would say that would be open space, rural open space that is maintained from those residential activities.
And the next one down, which is the one I raised earlier today, which, is the appropriate level of compatibility with existing development within the surrounding area. Does it achieve that?
In my view, it does, and I put forward my evidence about a working rural environment and what that might involve. And I looked to the rural provisions of the district plan, and I acknowledge in my evidence it's not crystal clear, but reading some of the zone descriptions in the plan and looking at some of those objectives, I believe there's an acknowledgement in the plan that there's a range of activities that can be undertaken in a rural landscape.
In terms of that policy at the moment, what would you say does that rural outlook for residential activities maintained as the application stand?
I
Okay, and then in terms of 6, so avoids mitigation remedies, adverse visual effects if cited immediately adjacent to a strategic arterial road. I don't think any of those apply.
So in this case, being located on State Highway 7, obviously it falls within that strategic arterial road. In terms of adverse visual effects, I would consider that also to be glint and glare, which my understanding can be managed through the proposed shade cloth and conditions. So I would.
And would you say the same for just the visual effects? Put aside the glint and glare, the visual effects avoided, remedy, or mitigate in relation to State Highway 7?
Just in relation to State Highway 7 and not the other visual receptors?
Well, it's only relating to strategic roads or district arterials and cliff roads. I don't think they apply. So it's only really, that's the only one that applies, I think, in that regard.
I would say yes to the State Highway.
Is that immediately or over in time?
Well, in terms of glint and glare, I'd say from immediately with the shade cloth, whilst you know your boundary planning is maturing.
So just going back, your overall conclusion in relation to that policy would be?
Would be consistent.
Okay. Probably I can probably got time to get through this one. Sensitive environment. So the word sensitive environment pops up in the plan. And I acknowledge it's not there's no definition of sensitive environment in the district plan. But under the issues section of the subdivision chapter, it does refer to subdivision and use can have a negative impact on sensitive environments, especially those environments valued for their landscape characteristics and biodiversity values. So while it's not a definition, the subdivision chapter does sort of spell out what a sensitive environment is. Would you think would be reasonable for us to take from that sensitive environment the sensitive environments referred to and then referred to in the energy chapter, which does refer to sensitive environments, are those valued for their landscape character or biodiversity values?
I think
fair for us to use that out of the subdivision chapter against those.
I think in absence of a definition, yes.
So, can I just take you to the introduction to the energy chapter?
Let me just pull it up. Chapter, yeah.
Got it. Okay. And that acknowledges that the council must have particular regard to energy efficiency, climate change, and the benefits to be derived from and the use and development of renewable energy. And then towards the end of that third paragraph, it acknowledges that large-scale solar electricity generation may become more viable in the future, and it goes on to state, however, energy generation, distribution, and use can cause adverse effects on the environment through modification of natural resources such as water bodies and ecosystems by impacting on landscape and amenity values. As such, the district plan seeks to restrict community and large-scale energy generation activities to less sensitive environments. So would you agree that that's the context within which we need to consider these provisions? So then when we get to the injection policies.
It's the context, but obviously having regard still to the MPS on renewable.
Yeah. But this plan is acknowledging solar energy, isn't it? Already.
It is in the introduction. I do find that I'm not sure it's necessarily being carried the way through its provisions.
But we'll come to some of those. So I was just going to run you through some of those while we're at it. So you see an objective 7.1, we get that sensitive environment, conflicts between activities and sensitive environments are managed. So in your view, is where the solar farm has been located a sensitive environment? Given what we've just been through and discussed, do you think it's a sensitive environment?
No, based off the evidence that I've read.
And what would that be? What's the evidence that you rely on to that?
So firstly, in terms of ecological values on site, the evidence of Dr. Bramley notes that the site doesn't have any significant ecological values.
And then what about, just going back to the definition though, we sort of discussed earlier, what about the landscape side of things?
And then based off that pseudo definition of sensitive environment, to me, that would be an environment that would have that may be in an outstanding natural landscape or have an overlay such as that. And that doesn't apply to this site.
So in turning to the next policy down, which I think is 7.1, you see in the explanation to that policy, it acknowledges that there is an available sunshine resource for solar technologies. Do you agree that that's important?
Yes.
Okay. And then amenity values and character are identified in policy 7.6. So does that suggest that this must be considered a sensitive environment? C4, 7.64.
Managing construction activities. This is a policy 7.6.
7.6, so as number 4. So yeah, managing renewable energy activities to minimise adverse effects by.
And then 4 is managing construction activities, including vehicle movement. Am I reading from this?
Yeah.
4's got maintaining amenity values and
That's 5. 7.6.5, maintaining amenity values and character.
Are you reading?
Yeah, district plan.
That must change. I'm just reading from the evidence, so. Your evidence has got it as maintaining amenity values as 4, so I'm just reading straight from there, sorry.
All right.
Anyway, so that's it's the maintaining amenity values and character that I'm just asking the question about. So that amenity values and character are identified. So would that suggest that this must be considered a sensitive environment?
No, my read on policy 7.6 is that applies to any renewable energy activity to ensure that adverse effects are minimised by maintaining amenity values, and what those amenity values are would obviously differ between sites. I don't take that to mean that the site has it is a sensitive environment off the read of that policy.
So do you consider that the proposal meets the intent of that in terms of maintaining amenity values and character?
Overall, I would say yes, but I acknowledge that there are differences and effects on different viewpoints.
Because you see, the reason why I've raised that one, just to backtrack a little bit, is because the reference to that sensitive environment, sensitive environments from the subdivision chapter refers to characteristics, landscape characteristics. So that talks about amenity values and character. So that's the reason why I'm just asking that question, testing you on that. So overall, you consider that it meets the intent of that?
Yes, I do.
I'm just going to touch on the operational functional need issue. Then I can probably break, I think, 20 past one. In your evaluation, you referred to operational functional requirements in your assessment here, but they're not part of the policy framework, are they? Not in the district plan.
Not in the district plan, no.
No. So I just don't understand what the reference was in paragraph 188 to the operational functional requirements when you're addressing the objectives and policies of the district plan. Quite specific, that wording. And I fully accept that it's sitting in the REG, but I couldn't find it in the district plan in relation to these aspects. The
energy provisions, I mean, in that introduction, I'll just go back and look at that, but there's acknowledgement that there's requirements to locate. That doesn't flow through into the policies. So my comment there is reflecting some of that commentary, but I acknowledge it's not that wording is not within the objectives and policies of the district plan.
Just going to see how much more I've got. I think we might finish there. You've got a few questions too.
You're doing a very good job of covering most of it. I have got one girly one, but
right. I think I have got a few more, and I'm probably going to take more than 10 minutes, so 5 minutes. So I think we've finished there. And we've probably got about, I suspect, about between 15 and 20 minutes go tomorrow, maybe half an hour. Because we're going to have to do, we need to deal with conditions. So I think we'll finish there, and we'll adjourn till 9 o'clock tomorrow morning.
Thank you.
Thank you.
Thank you. Yeah.